Court does call the case of Fixing Housing 401k, Florida, I think, versus Erica Ward and Aaron Ward.
Good morning, Your Honor. Zach Revolt on behalf of the plaintiff.
All right. And are the wards here? They are. Okay, good morning. All right, what is plaintiff's claim in this case?
Yeah, Your Honor. So plaintiff is seeking a possession judgment against the defendants related to breaches of a commercial lease between the parties. Ultimately, plaintiffs are just seeking a trial date to get a possession judgment that can be executed as soon as possible.
All right. I don't know, counsel, if you received a number of different documents filed by, I think you folks are represented by Donna Tope.
Yes, Erica and Aaron
Okay.
Ward, the tenants.
So, counsel, did you receive those?
We did, Your Honor, but we did not receive them actually until like Wednesday evening around 5 p.m. So very late.
Yes. And so, I mean, there have been some answers, but I'm not sure why she filed an ex parte motion to adjourn. I think they would be entitled to an adjournment for a week in any event. So what I'm going to do is I'm going to put this out 1 week, not granting her motion because I don't think it was proper to be filed as an ex parte motion. But there is an answer to the complaint, which it seems to me in reviewing it has potential counterclaims and a request to suspend the plaintiff's eviction action. So we need to deal with all of that, but I guess we'll have to wait till next week to do so. So what I will do is I'll adjourn these proceedings, folks, to November 7th, 2025. That's at 1 p.m. Folks, that is a in-person proceeding, so everybody will need to be at the courthouse.
And
Okay.
Your Honor, if I may, would you like my client representative in person as well?
Given, normally I would say that counsel can, for the plaintiff can represent it, but it would likely be fruitful if there was a representative, given what I see in the documents file.
Understood. Thank you.
All right. Thank you, folks.
Thank you, Your Honor.
Thanks, Your Honor.
Court does call the case of Maple Heights Apartments versus Jeffrey, is it Payette?
Yes, sir, it's fine.
I'm sorry, say that again, sir. You muffled there.
I said, yes, it's fine.
Okay, got you. You're still muffled, but I got you. All right.
And good morning,
Maple
Your Honor.
Heights.
Yeah, good morning, Your Honor. Sean Mock for the plaintiff.
All right. And what is plaintiff's claim in this case?
Yeah, this is an action for non-payment of rent seeking possession only. The rent to retain through the month of October is $1,650. Court cost of $170.05. The total amount my client's seeking right now through October is $1,820.05. Payment last made on this file, $500 payment made September 30th, 2025.
All right. Sir,
Yes,
how are you intending on getting this paid?
I could pay it all off that payment that they talk about this month and next month's rent, November's rent, all in November. I just need the payment plan. That's all. I could, but
I'm
My
okay,
job-
hold on, you're muffled again. I don't know what's wrong with your mic. I can kind of make out kind of what you're saying. You said you can have it all, including next month. When do you think you can have that?
before November ends, I have all of that before the month of November ends. What to have me in December, what I would be on track then.
Gotcha. Okay, so here's what I'm gonna do. You're entitled to an adjournment, so I'm gonna adjourn this matter out to November 7th, 2025. What at 1 p.m. That's an in-person proceeding, so everybody would need to be at the courthouse. But what I'm going to suggest you do, sir, is contact the plaintiff's counsel and see what you can work out in terms of a payment. Sounds to me like you've got a plan in place. See if that'll work for them.
Okay, thank you.
Thank you, Your
All
Honor.
right. Thank you. Court does call the case of Mill Pond Manor versus, is it Changning Pond?
Yes, Your Honor.
Good morning. Good morning, Your Honor. James Martone appearing on behalf of the plaintiff.
Good morning, Your Honor. Student Attorney Calvin O'Connell, joined by my partner Allison Futter and our supervisor Sarah Sallin from the University of Michigan Civil Criminal Law Clinic on behalf of our client, Mr.
Boy,
Fan.
that's a long intro. Go.
Apologies, Your Honor, but
Go on.
there is more.
There's more? Okay,
No.
go for it. I got all morning.
We are requesting permission to practice in your court under Michigan Court Rule 8.120 with the supervision of Ms. Sallin.
Have you been before me?
I have not, Your Honor.
I didn't think so. Where are you from?
I'm from Seattle, Washington, Your Honor.
Oh, it's really damp there. It's like rain, just rain. It's just, I don't know. Anyway, so where'd you go to undergrad?
The University of Washington in Seattle, Your Honor.
Oh, is that different? That's different than UW.
No, that is UW, Your Honor.
Is it? They're in Seattle?
Yes, North Seattle.
You understand that they beat my Maryland Terrapins, so you're in trouble. You should have said that was not the school.
I mean, I don't know if you know this, Your Honor, but I did switch sides after we lost the national championship. So I'm here at Michigan now. That's where my allegiance.
You didn't belong in the game. Listen. Anyway, I don't even know why you were there, but that's okay. All right. So are you from Washington?
Yes, Your Honor.
All right. So you went to UW and now you're at Michigan.
Yes, Your Honor.
Okay, I'll let it pass. Permission to practice is granted. Go ahead. Good morning, Ms. Sullivan. Yeah.
Good morning, Judge.
All right, what are we doing on this case?
Hi, good morning, Your Honor. This is a case for a termination of tenancy stemming from multiple breaches of a lease, a residential lease agreement. We're seeking, basically going to be asking the court for a trial date for us to seek a judgment of possession. I will note, Judge, that I did receive, it looks like, an answer in affirmative defenses from defendants, as well as a demand for a jury, as well as a motion for summary disposition. And so I think just looking for a scheduling order, Your Honor, to address all those issues.
Well, that's not entirely how we would do it. I guess the summary, since this is a summary proceeding, there's a question of whether or not rental payments were accepted.
Yes, Your Honor, that is correct. We did move for summary disposition in this case on the basis of what we believe are multiple park forest violations. Attached to our motion are exhibits, the first of which being bank statements showing about 3 months worth of rent acceptance after the August 22nd move-out date specified on the notice to quit. The second exhibit we have is a signed HUD recertification signed by Mr. Fan and the building manager, Mr. Christopher Writings, if I'm pronouncing that correctly. That's from September 30th. And lastly, we have a notice of processing of that HUD recertification and a subsequent rent increase that was sent to Mr. Fan. That rent increase was actually set to take place tomorrow. All of which occurred, several months after the expiration of the notice to quit, and aligned pretty neatly with the dictates of Park Forest there. And I will note, just briefly for the court, that Mr. Fan is with us here on Zoom. However, he has recently suffered a stroke, as a result of which his blood pressure consistently sort of reaches dangerous highs in stressful situations. So I just wanted to flag that for the court in case he does become unavailable momentarily. But in any event, for the sake of his health and, on the basis of those pretty straightforward notice violations, yes, we are asking that you grant our motion to dismiss today.
Your Honor, if I,
Counsel, yes, go ahead.
if I may address that, the Park Forest case doesn't apply here. This is not a non-payment of rent termination of tenancy. This is a termination of tenancy as it relates to multiple violations of, unauthorized destruction of process or unauthorized modifications of premises, destruction of property, aggressive behavior, all other types of.
Yeah, but that's fine, except that the basic premise behind Park Forest isn't necessarily that it's a non-payment of rent case. The basic premise is that the landlord has done things that have led the tenant to believe that the tenancy continues, despite what their complaints may be, whether it be non-payment or whether it be termination.
Understood, Your Honor. Understood, Your Honor.
So,
if I may, Judge.
yeah, go ahead.
We have been engaged with Mr. Fan's prior counsel in negotiations of a settlement with respect to this issue. They have been on notice that we have been postponing filing the lawsuit as we engaged in those discussions. It wasn't a situation in the Park Forest where the tenant was led to believe that the notice to quit was waived. Here, at all times, prior counsel and Mr. Fan was aware that we were continuing to enforce the notice to quit, and we were engaged in settlement discussions as a result, as it relates to that. As recent as end of September, Mr. Fan's prior counsel did identify that they could not reach an amicable resolution and suggested that we go ahead and file the complaint at that time. So this isn't a situation where Mr. Fan was led to believe that acceptance of rent or other actions waived that termination of tenancy notice. In fact, at all
I think that's going to be a factual determination. I don't know that one that I can make just on the thing. I understand what you may be saying, and I'm not sure. Well, I won't go into that. All right. So first thing is I'll need an answer to the motion for summary disposition. How much time do you need to do that, counsel?
Let me look. Sorry, Judge, just looking at my schedule. I'm out of town next week. Is it possible?
Then we'll do it then. No, go ahead.
Yeah, no, is it possible to, do you need an answer date or a hearing date?
Yeah, well, I just need, how much time are you going to need to file an answer, and then I can give you a hearing date?
If I could file an answer by the 14th, that would be sufficient time for me, Your Honor.
All right. So I'll indicate answer to motion by November 14th. I'm not going to need much time to necessarily look at that and grasp the issues. So when's my next Tuesday? 3? No.
Oh, Tuesday, sorry. December 2nd, after that.
That's my next day.
I'm sorry, November 18th.
November 18th. I can, if that gets in by Friday, then I can look at it and be able to deal with it over the weekend. All right. So what I will do is, to move this along, I'll need the answer to the motion by the 14th, and then I will set it for a hearing on the motion and a pretrial for November 18th. That's an in-person hearing. That's a Tuesday, and that will be at 9 a.m. And then I'll hear argument on it, and then we'll see whether we go forward.
Thank you, Your Honor. Judge, I'm sorry, Your Honor.
Yeah.
One housekeeping matter. I will note that Mr. Fan filed a complaint against Mr. Ridings in a separate matter. Is that it's case number 254C1603. It looks like it was a pro se filing. Is the court going to address that in due course, or is that something that we would consolidate?
My short answer would be no, but you have it.
I do. That was filed as a general civil matter.
So it's before Judge Barr.
Correct.
Okay. When was that? When was it filed?
It was filed on September 29th, and I'm not seeing any activity past that.
So nothing has
There's
gone
no
forward
feedback.
on it. All right. What I will do, I don't know that I can give you a straightforward answer. It's likely that what we'll do is we'll contact Judge Barr and probably bring it over because it doesn't make sense to, I don't know what the issues are in that filing. But it would seem to me that if they relate to the tenancy, it would be best that it be handled in one place. So
And it looks like
I will talk to Judge Barr about that and then we'll deal with it on the 18th.
Thank you, Your Honor. I appreciate it.
All right. Okay. Thank you, folks.
Thank you so much.
Thank you, Your Honor.
Take care. Seattle, have a good weekend.
We'll try. Thank you, Your Honor.
Yeah, all right. Take care, guys. Nicholas Schultz, Lake Rental 2 versus Ken Olson II. And Courtney Olson.
Good morning, Your Honor. For the record, Salem Saman appearing on behalf of the plaintiff.
Okay, I see Ken Olson.
Yes, Your Honor.
All right. Is Courtney here or no?
No, she's at the kids' Halloween party at school. I do apologize. I'm handling it for her.
She's at the kids' Halloween party?
Yeah, at school, our 8-year-old daughter.
That's an acceptable excuse? No, I'm kidding. No, I'm not.
I hope so.
I'm not going there. It absolutely is. I still don't understand this Halloween thing, but whatever. All right, what is plaintiff's claim in this case?
Basically, it's a non-payment of rent matter, Your Honor. My understanding is that the defendants in this case have represented to my client that they hope to be able to pay everything within a week. So if we can schedule this out 2 weeks and give them a chance to do that, maybe they'll resolve the issue.
Okay, would that be inclusive of November?
Actually, everything should be paid. It's about 15,600 includes
They did make
November.
a partial payment.
Oh, they did make a partial payment of 2,500, but again, they said that they will catch it up.
Okay, let me stop you, counsel. How much is currently owing?
15,600, that includes November.
That is,
Minus 2,500, right, Ken?
yeah, I paid 2,500 yesterday. I paid 2,500 last week. So that's 5,000 there. So I owe $5,400 to make rent current as of right now. November will be additional 5,200. But that's not due till tomorrow. So as we're talking, as of current right now, I owe $5,400.
That's
Is everybody in agreement on that?
Yes.
Okay,
Big
so
difference.
5,400 plus cost, right?
That is correct, Judge.
Okay, so Mr. Olson, you've indicated, or it was indicated that you can get that paid plus your November by what are you, well, why don't you tell me what you are intending on doing?
Well, I tried to make another payment this morning, but I sent Linda a screenshot of my bank. The web banking is down. So it's like the perfect day for that to happen. So she's seen it and said, okay, I'm going to have the $5,400 paid. I'm going to pay $2,500 today, or figure out how I can do it with the bank. Because we do it by Zelle. And then you can only do $2,500 per day. I'm going to send another $2,500 tomorrow. And then I'll send another $400 the following day. That'll get this paid up to now. And then November rent will be paid within the week. I'm finished up the job now. I'm on now, and I'll be paying November rent within a week.
Okay, do I have the 14th?
You do.
All right, so let me ask it this way. If I adjourn this out 2 weeks, as counsel suggested, to the 14th, you could have everything paid and then this matter can be dismissed. And while you're wonderful people, you don't have to come back and see me.
That would be great.
Which
you're funny
part?
and all, but
Not coming back and seeing me?
I mean, you're pretty funny.
You know,
I like that.
I am so sensitive and I'm hurt. Okay, so.
Well, you gave the guy a
Here's
hard
what
time
we'll
about
do.
his college. That was pretty funny.
All right, folks, here's what we'll do. And I think it may be a fair solution to work everything out. I'll adjourn this to November 14th, 2025 at 2 p.m. And that is an in-person proceeding, but if everything's paid, then it's certainly a dismissal can be filed and you folks don't need to appear. But if it's not paid, I'll need to have everybody here.
Okay.
Okay?
Yes, Your Honor.
And a Halloween party will not work as an excuse, no. All right. All right, guys, take care. Thank you very much.
Your Honor, God
Thanks.
bless.
All right, thank you.
Yeah.
Right.
Covington Apartments versus Alicia Sharp.
Good morning, Carolyn Cohen, P 49391, appearing on behalf of the plaintiff.
Alicia Sharp. She is not present. Would you like, you paid for the second service, would you like to take a default?
Yes, I would like to take a default judgment, Your Honor.
If you'd raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Your Honor, this is a health hazard based upon a roach infestation, which has caused problems in the premises, and there's been opportunities to try to remedy the problem, and the defendant has failed to appear, and I am requesting a default judgment today with a 10-day writ period.
And she's failed to correct or cooperate in the abatement of the health hazard. Is that correct, counsel?
That's correct, Your Honor.
Okay, I thought that's what you meant to tell me. Judgment to the plaintiff, that is by default for possession. There is no redemption amount with the writ to issue in 10 days.
Thank you so much. Have a wonderful day and happy Halloween.
Yes, same to you. And I think I had one more. Covington versus Husan Sandifer. That matter is dismissed on plaintiff's motion. All right, thank you.
Thank you.
When people sign in, I need to know what community they're part of, because I don't know what that is. I'm gonna talk about
Okay, I'll find out.
Court does call the case of Lakestone Apartments versus Janitra Campbell.
May it please the Honorable Court, Steve Gann, P 78219 for the plaintiff.
Oh, a Spartan.
I decided not to wear
No,
Spartan
no,
gear.
I'm not gonna say anything. I'm gonna let it go. I'm gonna let it go. If she were on the other foot, you would not, but I am so benevolent, I'm gonna let it go.
Until the 29th of November when your team beats my team this year.
All right. Okay, and Janitra Campbell. They are not checked in. If you'd like to take default, raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor. At
Go
this
ahead.
moment in time, I would move for a default. The current balance due and owing for rent is $9,321.94. There is $252 in court fees for a total of $9,573.94. That's $9,573.94. To the best of my knowledge, the defendant is not in the military, not incompetent, is over the age of 18, and the property has been kept fit for its intended use.
All right, judgment to the plaintiff, that's by default for possession.
Thank you, Your
Redemption
Honor.
amount in the amount requested, writ issue in 10 days.
Thank you.
Thank you. Lakestone versus Christine Fairley.
May it please the Honorable Court, Steve Gann, P 78219 for the plaintiff. I believe I saw her on the screen.
Yes, oh, there she is. Okay, I need a camera, ma'am, if we could. What is plaintiff's claim?
Current balance due owing is $7,372, 7372.97. Court fees of $252 for a total of $7624.97.
All right. Ms. Fairley, how are you intending on getting this paid?
I have already sought help from DHS. And I'm working
sorry?
on that. I've sought help from DHS. I think I put a filing there.
So you submitted an SCR?
Yes, I submitted an SCR and I'm working on paying that down this month. I submitted a check payment that they'll receive in 5 days from my bank. And also I I think I submitted a money order about a week ago for 1,400.
Okay, so that was a lot there. You did an SER.
Yes.
You sent in, I'm gonna take it in a different order. As you said, you sent in 1,400 a few days ago, or
Yes, I believe I think Monday, I think.
you sent it to
My
him on
days are
Monday?
jumbled up. I'm sorry. Yes,
No, it's okay.
I sent in 1,400 and I applied for an SCR and then I submitted $1,000 from my bank account.
Got it.
Which
Okay,
they'll
that's
receive
that's the one thing I was missing. So you think $1,000 will get to them, you think in 5 days?
Yeah,
Or
it'll for
thereabout.
sure get to them in 5 days. It's from my Huntington bank account. They can
Got it.
cut checks straight from my bank account.
Okay, so that'd be about 2,400.
Yes.
You're gonna have November rent click in. You've done the
Right.
SCR. How many people are in your household?
It's just me, Your Honor.
Okay, so just so you know, with the SCR, the maximum amount that they would give if they approve it is only about $410.
So there's other options that I could seek out, also other charity donations and stuff
Yes,
like that.
and I
which
mean,
I'll-
you can call Housing Access for Washington County, Hawk, and that number was on the, should be in your packet that you received, as well as the presentation that was done at the beginning of the court session.
Yes, I'll
Okay.
reach out to those numbers also.
Okay, so I'll give you an opportunity to do that. With the SCR, you need to file also in your packet, the rental assistance form. You need to file that with the court, and actually you already have. Never mind. You're ahead of me. All right, so we already have the rental assistance form. So you're gonna be entitled to at least one adjournment and maybe another one, okay?
Okay.
So right now, we'll just adjourn it out a week, see where we are at that point, okay?
Okay.
So I'll adjourn it to November 7th, 2025 at 1 PM. Ma'am, that is an in-person hearing, so I'll need you down at the courthouse, okay?
All right.
All right, thank you.
Thank you.
Thank you, Your
All right,
Honor.
thank you, Mr. Gann.
Please call the court. You have a great day.
You do the same. Scio Farm versus Janelle Baker.
Morning, Your Honor. Casey Matson, P87729 on behalf of plaintiff.
And Janelle Baker. You guys have her?
No.
Not checked in. If you'd like to proceed, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Go ahead.
Your Honor, we are requesting entry of a default possession only judgment. Rent to retain is $1,952.92. Cost of $190 for a total of $2,142.92 with a writ to issue after, I believe, November 10th.
Yes.
Yes, Your Honor.
Judgment to the plaintiff, that's by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Scio Farms versus Kevin Brookshire.
Casey Matson on behalf of plaintiff.
Kevin Brookshire, also not here. You may proceed.
Thank you, Your Honor. There was a payment made by Mr. Brookshire, leaving a balance of $25.85. So we would ask for a dismissal without prejudice, preserve that small balance.
Case is dismissed without prejudice, and the balance is reserved. Scio Farms versus Elise Liu.
Casey Matson on behalf of plaintiff.
I don't think I have her. Do you? Elise Liu, not present. You may proceed.
Thank you, Your Honor. We are requesting entry of a default possession only judgment. Rent to retain is $2,123.46. Cost of $190 for a total of $2,313.46 with a writ to issue after November 10th.
Judgment to the plaintiff satisfied default for possession, redemption amount, any amount requested with the writ issue in 10 days. Sile Farms versus Sarah Neal.
Casey Matson on behalf of plaintiff.
Said she's here.
She was, but she literally just dropped.
Okay, let me pass this one briefly. It looked like they appeared, but then dropped for whatever reason. Let's see if they come back in.
Thank you, Your Honor.
Sile Farms versus Taylor Smith.
Casey Matson on behalf of plaintiff.
And I think Miss Smith is here. Yes, there
Hi.
she is. Hello.
Hello.
All right, what is plaintiff's claim in this case?
Your Honor, we have rent to retain of $5,320.83, costs of $190 for a total of $5,510.83.
And Miss Smith, how are you intending on getting this paid?
Hi, so I filled out the SCR and then I can make this month's payment next week, but I was seeing if I could have to like before the end of November to pay off the rest.
Okay, let's back that up a little bit, okay, so that
Okay.
we understand what's going on. You've done the SCR.
Yes.
So with the SCR, there's a form that came in your packet called a rental assistance form.
Yes.
You'll need to fill that out with the tracking number,
Okay.
okay? And that it needs to be filed with the court by Wednesday,
Okay.
okay? Now, the next thing is that you said that you could make a payment. So what kind of payment, how much of a payment can you make, I guess is what I'm gonna say.
1,500 by next Wednesday. Is that okay?
Well, if I said no, what would you do? No, never mind. You could, no, don't answer that. I just thought I'd throw that out there. But you can pay 1,500 by the 5th, you think?
Yes.
Okay. All right. And then how are you intending on getting the rest of this paid, or what's your plan?
So I got let go from my last job and I just started working at this job last week. I had my at my new job last week. I had my employer write a letter for me.
Okay,
And
so
yeah.
so basically, let me shortcut it a little bit. Basically, you're looking to get some type of plan in place, and you hope that you can work out something to get yourself clear by the end of November.
Yes.
That's what you're looking at. Okay. So here's what I'm going to do. I'm going to indicate you're to pay the landlord the 1,500 by the 5th.
Okay.
I'm going to adjourn this hearing out to November 7th, 2025 at 2 p.m. That's an in-person hearing, so you'll need to come down to the courthouse.
Okay.
Okay. What I'm going to suggest is that you contact either the office, your landlord office, or the attorney's office, and see if you can work out some type of payment plan to get yourself all caught up.
Okay, perfect.
Okay.
Okay.
So we'll leave it that way. And just so you know, how many people are in your unit?
2. Just me and my daughter.
Okay, so just so you know that, so you're not relying upon it that to a great extent, even if you were approved for an SCR, that's only about $520.
Okay.
Okay, of that amount. Okay.
Okay. Thank you.
All right. Thank you. Have a great weekend.
You too.
Your Honor.
Sile Farms versus Shane Meyer
Casey Matson on behalf of
And-
plaintiff.
and Jordan Marshall.
I'm here, Your Honor.
Okay, you're here. Who are you?
He's with me.
Happy boss. I work in the office.
I'm sorry, say your name again.
My name is Jordan Marshall.
Okay, and you happen to work, gotcha. Okay. All right, what is plaintiff's claim?
Your Honor, a payment was made today, I believe. However, it wasn't certified funds, so we would just request an adjournment to allow for that payment to clear.
Gotcha. Okay. November 7th, 2025 at 2 PM. If everything's paid up, then we're good.
Thank you, Your
Thank
Honor.
you, Your Honor.
Okay, thank you. I was a little bit worried, Mr. Marshall, because see, Patty's kind of become a fixture and you kind of just push her out of the screen. So I was actually going to call the sheriff's department to come down because I didn't know who you were, but.
Oh, yeah, I understand. I do the same.
It's good. We all work that out. Okay. Scio Farms versus Jessica Jones and Shaman Jones.
Casey Matson on behalf of plaintiff.
Jessica Jones, Shaman Jones, they are not here. You may proceed.
Thank you, Your Honor. A payment was actually made with certified funds. So there's a small balance remaining for October in the amount of $19.39. So we would ask for a dismissal without prejudice, preserving that small balance.
All right, that will be so ordered. That case is dismissed with the reserving of the small balance. Scio Farms versus Melissa Injimba and Regina Miller.
Casey Matson on behalf of plaintiff.
Neither party is present. You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. Rent retained is $4,114.41. Cost of $230.00 for a total of $4,344.41 with a writ to issue after November 10th.
Samantha Beal, Ms. Beal, before the court with her counsel, Mr. Ocello, Ms. Nicholson on behalf of the state of Ohio. Ms. Nicholson, what are we doing?
Your Honor, it's my understanding the defendant will be entering a guilty plea to an amended M1 theft.
Mr. Ocello, is that accurate?
Yes, that's accurate, Your Honor.
All right, Ms. Beal, they're telling me you're going to change your plea to an amended charge. Before we get to your change of plea, I am required to go over some things with you, okay?
Yes.
How old are you?
42.
How far did you go in school?
Completed high school equivalency and some college.
Are you able to read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, Your Honor.
Has anyone promised you how the court would sentence you in this case?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, Your Honor.
Are you satisfied with the representation you've received from Mr. Ocello?
Absolutely, yes, Your Honor.
Are you currently under the influence of any drugs or alcohol?
No, Your Honor.
Do you take medication that interferes with your ability to understand what's going on?
No, Your Honor.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there's a signature. Did you sign this?
Yes, Your Honor.
Did you read this and go over it with Mr. Ocello?
Yes, Your Honor.
And you believe you understand what it says?
Yes.
This document says you're running a plea of guilty to one count of theft as a misdemeanor of the first degree that carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. Do you understand the maximum penalties?
Yes, Your Honor.
Now, you are presumed innocent of this charge, which means you cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, Your Honor.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, Your Honor.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of Mr. Ocello, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, Your Honor.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, Your Honor.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, Your Honor.
Now, the burden of proof is on the prosecutor at your trial. You're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, Your Honor.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, Your Honor.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, Your Honor.
Do you believe you understand each of these rights we've gone over?
Yes.
And you understand that when you enter plea of guilty, you'll be waiving all these rights. We will not have a trial.
Yes, Your Honor.
This is how you wish to proceed?
Yes, sir.
All right, Ms. Nicholson.
Your Honor, if this case had proceeded to trial, the state would have proven that on or about June 26, 2025 in Deerfield Township, Warren County, Ohio, The defendant accepted $225 via Cash App from the victim, as well as $10 in cash. That was to make purchases for the victim. The defendant did not make those purchases. And when she ultimately returned to the victim's location, she did not have the item she was supposed to buy, nor her money. The amount was, I believe, like $235. That restitution has already been paid.
Mr. Ocello, anything on those facts?
No, Your Honor.
Ms. Beal, did you hear the statement that she read?
Yes, Your Honor.
Do you admit and acknowledge what she said is true?
Yes, Your Honor.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over.
Yes.
What's your plea?
Guilty, Your Honor.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty. And based upon the statement of facts in your plea, the court will make a finding of guilty. I'm going to order a pre-sentence investigation, come back in a few weeks and do sentencing at that time. Okay?
Sounds good. Thank you, Your Honor.
All right, Mr. Cello, anything else?
No, Your Honor, not at this time.
All right, very good. Thank you all. Thank you, Louis.
Appreciate it.
Yep, I appreciate you. Judgment to the plaintiff, that is by default for possession, redemption in the amount requested with a writ to issue in 10 days. Sile Farms versus Marcel Doss Jr.
Casey Matson on behalf.
And
Oh,
go ahead.
Casey Matson on behalf of plaintiff.
And also Justice Richter.
Hi,
Hello, what's your name?
Justice Richter.
All right. All right, what is the claim?
Your Honor, we have rent to retain of $1,498.09. Court costs of $230 for a total of $1,728.09.
All right. Ms. Richter, how are you intend on getting that paid?
So I do plan on having it all paid up by Monday, as well as November's rent.
Okay.
The reasoning for me not having it paid was my brother, I'm his sole caretaker, and we just found out he has to have another open heart surgery. So I honestly forgot about rent. And then I'm like, oh my goodness, I gotta pay rent. So it was kind of just like life. So I plan on having that all paid.
So your brother was having surgery and you forgot about rent?
Well, I've been going to his doctor's appointments. We're scheduling his open heart surgery.
Got it.
Yeah, and this is our
No,
first big
you know what,
since my
Ms.
mom
Richter, I kind of said that facetiously. I get it. All right. Okay, I understand that. So you think you can get this all paid by Monday, including November?
100%.
All right, so here's what I'll do. I'll adjourn this to November 7th, 2025 at 2 p.m. Now that's an in-person hearing, but if you have everything paid, just double check and make sure you got everything paid. They're gonna dismiss this case.
Okay,
Okay?
thank you.
You are so welcome and good luck to you and best wishes for your brother.
Thank you.
Thank you.
Sile Farms versus Lawrence. It's a Brantel and Kill Brantel.
Casey Matson on behalf of plaintiff.
They are not checked in. You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. Rent to retain is $2,065.67. Court cost of $230 for a total of $2,295.67 with a writ to issue after November 10th.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days.
Thank you.
Valley Ranch versus Shamari Ayanu and Christopher Bonkoff.
Casey Matson on behalf of plaintiff.
And Yanu Van Kos, they are not present. You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession-only judgment. Rent to retain is $2,418.16. Court costs of $182 for a total of $2,600.16 with a writ to issue after November 10th.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Whitaker Oaks versus Talia Martin.
Casey Matson on behalf of plaintiff.
Talia Martin, they are not checked in. You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession-only judgment. Rent to retain is $1,696.46. Cost of $200 for a total of $1,896.46 with a writ to issue after November 10th.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested with a writ to issue in 10 days. Recall the case of Sile Farms versus Sarah Neal. Did she check back?
She did not. She is not approved.
She did not check back in. I think
Your
I've
Honor.
given that go ahead.
I do believe she probably logged off because she did make a payment. However, that payment was not in certified funds, so we just asked for an adjournment to allow for that payment.
Got it. All right. I'll adjourn it to the 7th, 2025 at 2 p.m. All right, in person. Thank you. And then Sile Farms versus Shannon Rousseau. I see you up there.
That is a dismissal, Your Honor.
Hello, Your Honor.
Yes, it is. All
Okay.
right, they're going to dismiss the case. You have any objection, Mr. Rousseau?
No objections. Thank you, Your Honor.
Thank you, sir. And then Sile Farms versus Martin Whale. That matter is also dismissed on plaintiff's motion without prejudice. And I've run out of files. All right. Okay. Thank you, guys. Court stands in recess.
To do that. It should be one little button.
Are you reading lips?
It's not. It's showing that you are muted, ma'am. You have to unmute, please. There should be an unmute button. You need to unmute. We cannot hear you, ma'am. You know how to do that. It should be one little button.
Are you reading lips?
It's not. It's showing that you are muted, ma'am. You have to unmute, please. There should be an unmute button. Come on. It's on every computer.
She might want to the bounding judge.
Huh?
She might be on her phone.
That might be
Aaron, if you're on
asking
your
too
phone,
much.
I would maybe log off and rejoin to make sure that it's able to connect to your audio.
We cannot hear you, and it's showing that you are muted.
On your phone.
Whenever you join, yeah, you have to allow it to connect to audio.
Maybe it'll work tomorrow.
I will not be here tomorrow, Judge.
Whatever is happening is not working, ma'am. And we're
Yeah,
out.
she's got to log back on to allow it to connect to audio.
Are y'all ready, ma'am?
No, sir.
Oh, okay. This might take a while.
How old are you, Ms. Foster?
This is a money issue, right?
You know what? I'll get in there. And then I can.
And what is she paid since our last event?
We haven't had.
This is our first event.
Oh, really?
Yes, Judge.
Let her out of custody and set it. So she could.
The reality is she's been on 10 years probation. She's done everything she's supposed to, but hasn't had the ability to pay the restitution.
Which is.
She hasn't paid anything.
Her total balance that she has been credited to restitution is $3,444.
Over 10 years.
Yes, sir. And it is amended to go to restitution.
No. It is showing that you are still muted. It's showing that you are still muted, Miss Green. We cannot hear you.
There she goes.
Okay, speak.
My apologies.
Okay. It's on now.
Yes, yes.
All right. Okay, in 15-22031, the state of Texas versus Aaron Felice Green, there was a motion to revoke probation that had been filed in July of this year, which has one.
Can hear you a little better, if you're okay with that. I did get your letter, by the way. What do you want to tell me, ma'am?
Well, just that I forgave Peyton. I love Peyton. He's a good kid, except when he has this anger. And everything was in my letter. Basically, I just wanted to tell Peyton what I told you.
Okay. Is there anything else you want to tell me?
No, I just don't want him to go to prison. I'm not mad at him. I wasn't from the moment it happened. I forgave him. And it was such a stupid thing to trigger all of this. He's all I have left of relatives. If you take him away, I'm completely alone and I need some help. He's kind to me when he's not in this anger mood. Basically, that's it.
Thank you, Miss Tracy.
principles of sentencing and aggravating mitigating factors and seriousness of the offense. In the state's position, this is a prison case. As the court's aware of Mr. Racy's history of violence, and all of that history of violence has been directed towards his mother, Elaine Racy. 2023, the defendant was charged with a Mrs. Racy, and that was he was given an opportunity at that time to address whatever issues he could regarding his behavior. And it was identified at that time that alcohol was a significant issue, and he engaged in treatment. He was on supervision to this court, I think barely a year or so, and at the request of Mrs. Racy, that supervision was terminated based upon the information that we have, that she then allowed Mr. Racy to move back in with her, and the violence began very shortly after that and has continued up until we have another major felony assault on her. Both of those cases, the 2023 case and this case, involved strangulation and threats of death, that he was going to kill her. This case involved threats against her pets, threats to burn down their house. They're very serious violence, both in terms of the conduct that he engaged in and the conduct he pled guilty to, and the threats he's made of future conduct in the case. I do not say this lightly. I think the history of violence beginning in 2009 against his mother and the escalating violence against her poses a very serious threat of death to Mrs. Racy if he's allowed to have contact with her. I understand her perspective. I think anyone can sympathize with her in terms of being a mother. She does not want her child to go to prison, but by the defendant's own statements during the PSI, he denied, and there was no indication on the date of the arrest that he was under the influence of alcohol at the time this occurred. He denies having any significant mental health issues. There's no history of mental health, hospitalizations, or other psychiatric care. The only medications he's taking are for blood pressure. The defendant denies that he has any issues with alcohol now. He rates himself as a 1. He has no needs in terms of treatment needs. And I think it's telling that in his statement account of the events this date, he in fact in the end denies that he engaged in this conduct. And the only thing that he takes any responsibility for is what he calls a bad choice to not open the door when the police came. I think that's about as much minimizing as you can get, the least amount of remorse and acceptance of responsibility for the ongoing significant violence that Mr. Racy has continued to engage in. I think there are really no mitigating factors in this, that anything other than a prison sentence would demean the seriousness of Mr. Racy's conduct. I think his history and his history on supervision demonstrate that he has not taken account for changing his behavior, and therefore the state's recommendation as to count 1, strangulation, is 36 months in prison. As to count 3, inducing panic, is 18 months in prison. I think that it is necessary to incarcerate him and segregate him from the community, but from Mrs. Racy in particular, for as long as the court has the ability to do so. Thank you, Your Honor.
Officer Henry, anything from probation?
Nothing further, Your Honor.
Mr. Wendell?
Your Honor, thank you. Judge, I would respectfully submit that Mr. Racy is appropriate for community control. I think the issues that he has can be adequately addressed with that. I think that's borne out by recommendations from Star Community Justice Center, their acceptance for admission. Certainly, I think he does have a history of substance abuse. Talbert House certainly recommends him for anger management. I think certainly that is appropriate. I would note importantly, there is no presumption of prison in the matter, despite the fact that it is a felony of the 3rd degree, the strangulation. Judge, yes, he was on a previous period of community control that was terminated successful. Certainly there is a relapse, if you will, inappropriate criminal behavior. I don't mean to minimize that. Judge, he does have a good employment history. You'll note that he's been a yard worker and driver. That was been verified by adult probation notes immediately prior to this matter and in the years preceding. Judge, I think he is an appropriate candidate for community control. His issues and problems can be effectively addressed through that. We'll submit on that basis. Thank you, Judge.
Mr. Racy, you get the last word in all this. What do you want to tell me?
I'm sorry for everything that happened. I love my mother. It's been an awful year since my dad died, and just everything has spiraled downhill. That's no excuse, but it's just been a bad year.
So here's where I'm at on this, Mr. Racy. You know, a couple of years ago in Ohio, we gave the victims the constitutional right to speak. And I mean, we always did that in Warren County. We gave our victims the opportunity to speak. But I think when the people of Ohio embodied that in our Constitution, it made a lot of sense, but it doesn't make a lot of sense for us to have constitutional right for a victim to speak and not listen to what they have to say. And I understand, Ms. Racy, your position in this, that you love your son, that you forgive your son. And one of the things that I did, Ms. Racy, is I read your letter. I also read the letter that you sent me in June of 2023, which basically said exactly the same thing, that you love your son, that you forgive him, that you want mercy for him, and you wanted me to remove the protection order. In that case, it was very similar to this case, without the involvement of all the law enforcement afterwards. So I do understand, Ms. Racy, that this puts you in a bad spot, puts me in a bad spot. There's three things I do up here, Mr. Racy. I protect the public, I punish offenders, and I rehabilitate people. Those are the three basic goals that I have when I sentence somebody. I put you on probation once before. Everything seemed to go along pretty well during the year that you were on supervision with me. We have the alcohol issue that is sort of comes up frequently. As Mr. View pointed out, I don't know that you are in a position where you really acknowledge that. You know, you've been in jail for 103 days. That seems like enough time to punish you for all this. But here's the thing, Mr. Racy, and this is, I need to protect your mom from you. And that's just the bottom line. Somebody's got to do it, and it's got to be me. I am going to impose a 36-month prison sentence on the strangulation and a 12-month prison sentence on the inducing panic. I'm going to be ordering those to be served consecutively. So you are going to receive a 4-year prison sentence. And I apologize to you, Ms. Racy, that the hardship this works on you, but I cannot have this continue to happen over and over in my jurisdiction, Mr. Racy. I just can't. I think a consecutive sentence is necessary to properly punish you and to protect the public, given your criminal history in the case. So I think consecutive sentences are necessary. I'm not going to impose a fine. I am going to impose the costs. This includes a mandatory period of post-release control. Then it escapes me now. 1 to 3 years. So you're going to be supervised by the adult parole authority upon your release. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you receive for the new felony. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, they'll all be provided to you at no charge. Anything else we need to do? Anything that I forgot?
No, Your Honor. Thank you.
I'm sorry, Miss Racy. I really am. Good luck to you, Mr. Racy. We're in recess.
One ground of an issue, and that is that the defendant is in arrears and it shows $35,000 in arrears as of June 9th. That must be for assessed fees total. Restitution was ordered in the amount of $30,000, and apparently not very much has been paid toward that in 10 years, correct?
Correct.
So what are we going to do? The victims are entitled to be reimbursed. That's how we fix problems. This was an arson, correct?
Yes.
Where damage was done, I guess, to the owner's building, the building's owner, financially.
Yeah.
So what are we doing about it? I mean, this is when the defendant is looking at up to 10 years in prison, but in 10 years, literally nothing has been paid toward restitution. Everything's going to other fees, correct?
No, sir. It
No?
was amended in 2021 for the payments to go to restitution.
So, okay, since 2021, how much has gone to restitution, Tom?
Well, total, there's been $3,434.
Okay. All right. So, Ms. Green, and right now, we're just looking at whatever she pays goes directly to restitution. Correct, everybody? All right. How much are you able to pay a month toward restitution?
What I've been paying, monthly, except for these last couple of months, it's been $100 a month.
Okay. And is that the most you're able to pay, 100 a month?
Yes.
Everything else goes to other necessary expenses?
Yes.
All right. Anybody want to ask this lady something?
I don't want to
Anything the
ask her.
state is curious about anything we're going to ask to get more restitution here?
No, sir.
Have you talked to her about any other options that are available? She's on a fixed income of some sort.
Yeah.
What is your fixed income, ma'am?
Well, I'm not working. I haven't been able to get a job with my background.
What is your fixed income right now? How much should you get in income?
Only thing I receive is food stamps. My husband is working and has been providing for me. And we've been working, he's worked from paycheck to paycheck, and he does the best that he can.
What does he do for a living?
He works with Amazon, with driving the trucks in the yard of Amazon.
Okay, and what is his income? Do you know?
Well, I should know that, but it's about 15 a week.
Okay. So that's about $40,000.
You're talking about in a year. Huh?
Yes, in a year.
Give or take, yes.
And again, your income, you say all you receive are food stamps? You don't receive any other type of income?
No, nothing.
Okay. From probation, anything you know about that?
No, sir, she does not. I'm not sure why, because she has, there's some mental health issues. I'm not sure why she's not receiving Social Security.
You don't receive Social Security or any other type of governmental subsistence?
I got denied. I went as far as my doctor and everything with that, and I got denied because they did X-rays of my back and my knee. Physically, I've been having troubles with my thyroid and getting my weight off. It's been, I barely can walk sometimes. My legs get so swollen.
Okay, all right. Well, anything anybody wants to add about this? I don't see any evidence in the record that shows she can pay more than she's paying.
Right, she's been paying $100 consecutively since January of 20.
Well, that's, we'll just,
And she doesn't have any other violations of any kind.
yeah, $100 only gets you back 1,200 a year. So we can do the math. We're looking at 20+ years.
Any other violations, no positives, she was reporting.
The victims have to get paid back. So anything else anybody wants to add? It all goes back to, it's all going to restitution now. She's on an inactive type.
They returned her case when she turned herself in and her case expired. They said that they would be willing to take it back if we wanted to send the courtesy supervision back to Tarrant County.
What do you think we should do?
I don't know, but I don't know
If
what's.
restitution is, it goes to Tarrant County, she's still gonna have to pay restitution, right?
Right.
So. Do you live in Tarrant County?
Yes.
That's when. Well, what? Which one is the most cost effective for Jefferson County? That's who I represent. I mean, why are we bringing it back down? I let them do it, right? Let them handle it where she is. That's more convenient for everybody, isn't it?
For her to report to them.
Yeah, and then pay through them
Here.
and monthly, and that's what I think.
She sends her payments to us.
She sends directly to you?
Mm-hmm.
Well, there's no reason she needs to be coming here.
Yes.
I don't think she does not come here, and I don't think
So
that's possible
we'll
for
just
her to come here.
maintain the status quo. She can report to Tarrant County, but those payments must be made at least $100 per month, ma'am. Do you understand, Miss Green?
Yes.
We'll review it, what, in a year?
I suppose, Judge.
I guess that's what we'll do. Okay, we'll review it in a year because otherwise nothing has materially changed in this situation. All right, good luck. And we'll see you back in a year unless you somehow win the lottery.
No. I can hope, sir, because if there's any way, I would like to repay those people every penny.
Well, that's what's right. I mean, I know that's what you want, but that's what's right, but it's got to be done. So we'll do the best we can, okay?
Yes, thank you so much, sir.
Yes, ma'am. Okay. Anything else, Ms. Minaldi or State?
No, sir.
No? Okay, we're in recess on that case. Gavin Bond. And that's Mr. Shalander. Are we ready on Mr. Shalander?
He's getting the defendant to sign off the back right now, sir.
Aaron, you can log off. We're done for today.
Yep, thank you, ma'am.
Thank you.
Okay, thank you.
There we go. There we go.
Are you going to do a courtesy supervision order? Okay, I'll send it back. Yeah, I mean, we have one, but maybe it wouldn't hurt to do a new one.
I don't think Jefferson, under these circumstances, it's an awkward thing. And
She can't.
there's no reason that if they're willing to continue to supervise her, that's just practically the right thing to do.
We're actually seemed a little irritated for requesting a motion, and I said, I can't let this case expire.
That's that's ridiculous. That would be ridiculous.
Talk to my
That
judge.
is,
I mean,
I can't imagine
well,
that victims are not considered in that county, but they ought to be, but that, maybe they misunderstood, but who in the right mind is going to say, yeah, I work for the people and I am not interested in their receiving restitution, the victims being dealt with. We could have done something to help them, but we don't. That's not right. That doesn't make sense.
I've never encountered that before. And she basically came out and said to me, well, you can't revoke her for money. And I said, I can stop her case from expiring. Yes, I can do that. I mean, her go before her judge. But she had to it was kind of weird. I've never had that before, though.
They're not Jefferson County. That's for sure.
Right.
Is it?
Right now? Your age?
16.
Okay. So we're going to be going dark on this since it involves someone younger than 17 years of age. You.
Just one moment, Your Honor.
Yes, sir.
Your Honor, it's a termination case. And as the court knows, it was adjourned last week.
Mr. Wilkerson's case was adjourned.
I'm sorry,
last
Your
week?
Honor. I've got could you pass this, please?
All right, I'll pass the matter. All right.
Thank you.
We'll get right back to you, Mr. Wilkerson, shortly.
Yes, sir.
The Haven versus Marshawn Brooks.
James Fink for the plaintiff.
They are not here. If you'd like to take a default, please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead, sir.
Your Honor, this is an action for non-payment of rent. This defendant owes $1,791.45 in rent. The costs are $175 for a total of $1,966.45.
Judgment to the plaintiff. That is by default for possession, redemption amount in the amount requested with the writ issue in 10 days. And the Haven versus Nikki Hess, that matter is dismissed on plaintiff's motion.
Thank you, Your Honor.
Let
I'll
me
be right
know-
back for Mr. Wilkerson.
All right, fantastic. Arbor Meadows versus Rachel Cox.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of Arbor Meadows.
Good morning, sir. And Ms. Cox?
I'm here, Your Honor.
All right. This is a termination of tenancy action. Plaintiff's claim in the case.
Plaintiff's claim, Your Honor, is that Ms. Cox's dog bit a guest of another resident. Pretty severe bite to the right hand. Police were involved. The dog ran loose.
All right. Ms. Cox, what's your position on this?
I have several, actually. My dog is not aggressive whatsoever to kids, humans. It doesn't matter. She is very friendly. The only reason why she bit was because he tried to restrain her and grab her collar, and she was scared.
Was Well, where did I don't think there's a dispute that the fight happened. Where did it take place?
It happened in our neighborhood, in Arbor Meadows.
Okay, so it was in the neighborhood?
Yes.
Okay. Who was the dog leashed or?
She was outside, and a neighborhood kid has been letting her off, and she got loose because someone let her off.
Okay. All right.
Your Honor,
So,
the
ma'am,
dog, the
Go
dog
ahead.
was loose. It went after another dog. The victim tried to separate the two dogs and was bit.
Okay, that's it. Okay, I got you. Okay. Ma'am, are you gonna have an attorney in this matter? How are you intending on proceeding in this case?
I don't have an attorney, no.
All right. So here's what I'll do is I'll adjourn it out for you to try to seek some legal counsel on it, regarding determination. In our video, there's the Michigan Clinical Law Program, as well as legal services that you can contact us, as well as the Washtenaw County Bar Association, to see if you can get representation regarding this issue, okay?
Okay.
And then we'll figure out how we're going to proceed. I would adjourn the matter to November 7th, 2025 at 12 noon. All right, that's an in-person hearing, ma'am, so you'll have to be at the courthouse in person, all right?
Okay.
Okay, thank you. We'll see you then.
Thank you.
Court calls the case of Beal Properties versus Callaloo Jackson.
Daniel Landsman, Your Honor, on behalf of the plaintiff.
Jackson, are they here? No, here. They are not here. If you'd like to take a default, raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Go ahead.
Thank you, Your Honor. Mr. Jackson leases the garage unit at 509 North River Street Garage in Ypsilanti. It is a month-to-month lease. Mr. Jackson was provided with 30 days notice and has failed to surrender the unit. That's why this action was filed. He is not present. We would request that a possession judgment enter terminating the tenancy as to this particular garage.
Judgment to the plaintiff, that is by default for possession. No redemption amount, writ to issue in 10 days.
There's no redemption, yeah, Your Honor, there's no redemption amount as a determination action.
Yeah, no, I said that.
Okay,
No redemption.
I misheard. I'm
No
sorry.
redemption, writ to issue in 10 days. Westridge Mobile Home Park versus Michelle Cates.
Daniel Landsman for the plaintiff.
Not here. I don't have one either. They are not present. You may proceed, sir.
Your Honor, they're not present because they satisfied their rent arrearage this morning. Plaintiff moves to
Okay.
dismiss without prejudice, and we will be submitting a dismissal.
All right, fantastic. That's why they're not here. Good explanation. All right, Westridge Mobile Home Park versus Wells and Westridge Mobile Home Park versus Beverly. Those matters are dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor. Have a great weekend.
You do the same, sir. And back to Riverside Apartments versus John Wilkerson and Joshua. Mr. Wilkerson is present. Mr. Fink?
Thank you, Your Honor. So it is a termination case, but it's a health hazard termination case. And technically, this is the first hearing. Mr. Wilkerson, of course, was scheduled for last week. This is an issue of the overwhelming pet odors in the building affecting other tenants in the building. Feces on the floor near the kitchen. I don't need to go over everything on
Got it.
on Zoom, Your Honor, but we would like the tenancy terminated. We also filed a 1-month lease violation notice to quit also on October 3rd. So next week, if we don't have a resolution, we'll file an amended complaint so that this is both a health hazard and a lease violation termination.
Got it. All right, Mr. Wilkerson, what's your position on this, sir?
Yes, sir, I'm moving. I have a new place secured as of November 7th. I just request a couple weeks' time to be able to move and clear out the unit.
Well, here's what I'm gonna do. I'm gonna adjourn this out 1 week to November 7th, 2025 at 3 p.m. That's an in-person hearing. What I'm gonna suggest to you is you contact Mr. Fink's office and try to arrange the time frame for you to vacate the premises, okay?
Yes, sir.
All right.
Your Honor, two things.
Yes, sir.
Would the court please, for the ROA, note a default for Joshua Wilkerson, just in case we don't have him show up? And
Yes, for Joshua defendant 2. Yes.
Could we give Mr. John Wilkerson advice regarding MCR 4.201J so that if he and I can enter into a COD for him to surrender possession, he won't have to come back?
Mr. Wilkerson, if there's there's a procedure by which there wouldn't be a judgment, but you would be consenting to move, as it seems to me that you are, there would be a conditional order, what's called a conditional order of dismissal. That may be able to be worked out. And if it gets worked out, you would not have to then come back after you sign it or give permission to have it signed. You understand that, sir? All right. So if that can all be worked out, I'm going to advise you of certain rights. And that is that within 3 days of my signing of that, you have the right to think about it. And if you believe that there's some legal confusion or some legal issue, some confusion on your part, some mistake on your part, or something that some right you didn't assert, you'd have those 3 business days to file a motion with the court to ask that that be set aside. You understand that, sir?
Yes, sir.
Okay. So you can enter into the agreement, long and short of it, you can enter into the agreement, but you have time to think about it after you've done so, okay?
Understood, sir.
All right. Okay, November 7th, 3 p.m. All right.
Yes, sir.
Thank you.
Thank you, Your Honor.
Thank
Thank
you.
you. That's it. That's it for that block. Wonderful. We're done till
noon.
Nope, I'm not coming back again. I got lunch. Am I gonna get lunch? You guys need to feed me. All right. Court of State in recess.
And then what are we doing? Are we setting the trial date for identification purposes?
No, Your
Entonces,
Honor.
si él está diciendo que es los tickets que le dieron, él no es esa persona, entonces, ¿para qué estamos haciendo nosotros, tomando una fecha para un juicio por juez, identificar, ver realmente quién es él?
The tickets he has in hand are the tickets as listed on the docket for this, so he's not challenging the tickets, just that his name is not correct.
Los números de ticket que tenemos corresponden a los números de ticket que él tiene. Él lo que está disputando es que el nombre no es el suyo.
Well, it looks like more than his name is not correct, because with all due respect, Mr. Ordonez, I don't believe he's born in 89 either.
Y bueno, no solamente está errado el nombre, porque con todo respeto, señor Ordóñez, aquí dice que usted nació en el 89. Yo no creo que usted haya nacido en 1989.
Yo soy de 1972. Tengo 52 años.
I was born in 1972. I'm 52 years old.
So it's more than that, just the name that's the problem with these tickets. If he's not, the case number that he gave me. Also, he says that the street is not his, but that could have changed in the interim, but the birth date and the name should not have changed.
Exacto, entonces es algo más que solamente su nombre, porque también el número de la calle que me está dando es diferente al número de la calle que tiene la boleta.
Así es, señorita.
That's
Así es, señor
right,
juez.
Your Honor. That's the right, Your Honor. That's not the number, my address.
So where did the tickets come from?
Entonces, ¿de dónde salieron los tickets?
We can set a trial date and sort it out on the date of trial.
Yes, Your Honor, that's the way to proceed, I would think.
Bueno, entonces podemos seguir con un día para un juicio y ese día pues se determinará por qué razón está así. Sí, su señoría, yo pienso que esa es la forma de proceder.
Unless you want to speak to the city attorney again about this.
Well, I take that advantage, I take that option, Your Honor, I'd like to speak to her.
Sí, a menos que usted ahorita, señor Berry, su abogado, hable con la fiscal. Sí, su señoría, eso es una oportunidad que me gustaría. Déjeme hablar con la fiscal primero.
Okay, well, tell her we have a name that's not correct. We have a date of birth that's completely not correct. And some other inconsistencies with the ticket. Join the breakout room, please, and see if you can talk to her.
Thank you, Your Honor.
Está bien, señor Berry. Por favor, hable con la fiscal e infórmele que tenemos un nombre que no es correcto, una fecha de nacimiento que no es correcto, aparte de otras cosas que no coinciden. Por favor, vuelva a la sala de consulta privada y hable con la fiscal. Do you want us
You can stay.
go there too? Okay.
No,
Podemos quedarnos aquí, pero ponga su micrófono en silencio.
Okay.
All right, are we ready, Ms. Harris, on Mr. Lake? Ms. Harris? Ms. Harris, I've been waiting on you.
I'm sorry, I must have missed it. I did need help getting Mr. Lake out of the breakout room.
Now, let's go back on the record. For Mr. Lake, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, we are respectfully requesting a trial date.
All right, Mr. Lake, I'm gonna give you a trial date of November the 21st, 2025 at 9 a.m. If there's nothing further, best of luck to you. Have a very good rest of your day.
Appreciate it. You as well.
Thank you. This is the city of Detroit versus Deontay Lamar Lentz. Case number SP 159-04681, SP 176-97701, SP 178-9002, counts 1, 2, and 3. Appearance for the record, please.
Erica Harris on behalf of the defendant. Please state your name for the record.
Deontay Lentz.
All right, good morning to you, sir. Today is date and time set for a pre-trial. Ms. Harris, Ms. Harris is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial.
Your Honor, was counsel requested?
No.
Thank you.
Pass the matter. All right, Mr. Berry, did you get any response?
We need to set the matter for trial, Your Honor.
Let's go back on the record, Mr. Ordonez. Mr. Ordonez, we're gonna have to set it for trial and get this thing sorted out, okay?
Señor Berry, ¿habló con la fiscal? Sí, hablé con la fiscal. Vamos, ¿y qué desea hacer? Vamos a tener que llevar este caso a juicio. Señor Ordóñez, habla su micrófono. Señor Ordóñez, entonces sí, vamos a tener que darle una fecha para ir a juicio para poder esclarecer este asunto.
Ok, señor juez.
Okay, I'm ready, Your Honor, to write it down.
For the 21st, 2025 at 9 a.m. If there's nothing further, sir, I wish you the best of luck. Have a very good rest of your day.
Your Honor, I missed the first part, the month, November?
November the 21st.
First. Okay, thank you, Your Honor. Señor, ¿tiene que volver a comprar by Zoom, Your Honor?
Yes, come by Zoom.
Ok, señor Ordóñez, tiene que comparecer igual que en el día de hoy, con el mismo número de ID de Zoom que utilizó hoy, el día 21 de noviembre del 2025 a las 9 de la mañana.
Ok, ¿está bien?
Ok, that's very good.
Muchas gracias.
Ya se puede conectar. Thank you very much. Thank you very much. Have an excellent day. Bye bye. Thank you.
Bye bye. Bye.
Okay, Your Honor. So that's.
I think that's it.
Okay. Thank you very much, Your Honor. Thank you very much, everybody. Bye bye.
Good day. Have a good day. Mr. Berry. Mr. Berry, this is the city of Detroit versus Jason Leo Davis Lewis, case number SP 1789728, counts 1 and counts 2. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Lewis.
Unmute yourself, Mr. Lewis, please.
Jason Leo Davis Lewis.
Good morning to you, sir. Today is date and time set for a pretrial. Mr. Lewis, speak to Mr. Berry. He's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I'm gonna put you in the breakout room with them. You let us know what you want to do when you come out, okay?
Okay.
Join the room. Let's pass the matter. Lamontez O'Rear.
Yes.
Good morning. This is the city of Detroit versus Lamontez O'Rear, case number SP 170901442. State your name for the record, please.
Lamontez O'Rear.
All right, good morning. You're here because you were, I'm in or not guilty plea on your behalf, give you a $0 bond. You're supposed to pay this $240 and you never paid it.
Yes, I was really coming in today to try to get another week because I had to pay bills.
Is that all you need is a week for sure?
Well, my next payday, yeah, about a week, yeah.
Come back on our review on the November the 14th. Come back on November the 14th at 8:25. Edit any div that kiosk in the city of Detroit. I'm told you can upload the div that app to your phone, or you come on down to the courthouse and pay it in person, all right?
Okay.
Nothing further, sir. I wish you the best of luck. Have a very good rest of your day.
Thank you, you too.
Thank you. All right, let's go back on the record with Mr. Lentz. Mr. Lentz, I've given you an opportunity to speak to counsel. Counsel, your client wants a trial date.
Yes, Your Honor.
All right, Mr. Lentz, some of the trial date. It's gonna be 11, 17. All right, 9 AM, Mr. Lentz, 11:21, 9 AM. If it's nothing further, have a very good day. Best of luck to you. City of Detroit versus Antoine Demar Green, case number SP 14962812. Appearance for the record, please.
Sherika Harris, on behalf of the defendant, please state your name for the record.
Antoine Green, unmute yourself, please. Take your hat off, please.
Yeah, how you doing, sir?
Take your hat off, please. State your name.
It's off. It's off.
State your name for the record, please.
Antoine Demar Green.
All right, good morning to you. Day is date and time set for arraignment on the bench. Go ahead, Counselor.
For purposes of arraignment, my client stands mute, and I'll note, I believe his screen is frozen.
All right, enter not guilty plea on his behalf, give him a $0 bond. Mr. Green, I'm gonna put you in a breakout room with Ms. Harris. She's gonna get you an updated offer. You might want to run his license too. If you don't like the offer, you have an absolute right to a trial. Join the room. Let us know what you want to do when you come out. That's the matter. Let's go back on the record with Mr. Jason Lewis. Mr. Lewis, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Your Honor, we seek a bench trial date.
All right, that was- you want me to put it on the same page? Let me put it on the same page. All right, Mr. Lewis, November the file is November the 21st, 2025 at 9 AM. If there's nothing further, sir, I wish you the best of luck. Have a very good rest of your day, please.
All right, you too. Thank you, sir.
Here's something that's come out. All right, let's call the city of Detroit, Mr. Berry versus Trayvon Lohman, case number SP 133-73501. SP 163-21623 at 19-277-4701. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Lohman.
Trayvon Lohman.
All right, good morning to you, sir. Today is date and time set for a pre-trial. I want to put you in a breakout room with Mr. Berry. He's going to get you an updated offer. Keep in mind, if you do not like the offer, you have an absolute right to a trial. Join the room. Let us know what you want to do when you come out.
All right.
Okay, great.
Yeah, man. You see those, just the license thing.
Just whatever you have, just make a little list on it.
That's when you see just the license.
Like
thing.
a driver's license.
Yeah, and there's not much more than that. When you see the laundry, let's see reinstatement. Automatic. But then you also see payment of reinstatement. All right, Mr. Berry, Mr. Lowe, let's go back on the record with Mr. Lowe. Mr. Berry, Mr. Lowe has a valid driver's license.
Yes, Your Honor. And we would move for dismissal of all matter.
I ain't want 12. I want a 1021. And that bitch came in 0517.
Wait a minute, don't talk about your lottery here. All right, Mr. Lowe, I'm gonna dismiss your cases. You still owe a lot of money in civil infractions. You know that, don't you?
Yeah.
Loman. I'm sorry, Loman, sorry. I'm gonna waive the warrant fee. You're gonna pay the reinstatement fee.
Excuse me, I paid the reinstatement fee.
Now, you still got some other reinstatement fees.
Oh, okay, got you, okay.
Misdemeanor case. I only see one more reinstatement fee on a misdemeanor case.
Okay,
All right, so you're gonna have to pay those civil infractions. These misdemeanors are dismissed. Best of luck to you. Have a very good rest of your day, okay?
thank you, you do the same, John.
All right, take it easy. City of Detroit versus Leticia Jean Lowe, case number SP 1424174, counts 2 and counts 3. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Lowe.
Latasia Jean Lowe.
Hey, I'm sorry. Purpose of arraignment, counselor.
Your Honor, we would waive the reading of the information and stand mute.
Enter a not guilty plea on your client's behalf. Give your client a $0 bond. Ms. Lowe has a valid driver's license. She also has an old improper display of plate that went along with this ticket that's in default. I don't know if their city attorney is gonna be willing to call it a wash or not, but you can check. Ms. Lowe, I'm gonna put you in a breakout room with Mr. Berry. He's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the room. Let us know what you want to do when you come out, okay?
Okay.
Let's pass the matter.
What'd you say? Yeah.
You can have it your way. That tickles you. That tickles you.
They do. The Burger King. Right up and order some fries.
That's cheese.
Just got them thinking of Burger King. Jeez.
hecho de ir a juicio. Por favor, acepte la invitación para para ir a la sala de consulta privada.
Find your room, let us know what you want to do when you come out.
Por favor, únase a la habitación.
It's in there.
Is he there? Okay,
Yes.
thank you, Your Honor.
All right.
Thank you.
Let's pass that matter. Let's go back on the record with Ms. Lopez. Ms. Lopez, up to you. Speak to counsel. Counsel, what does the client want to do?
Your Honor, my client is going to admit responsibility to the amended count of limited access 1 to 5 over with the misdemeanor matter dismissed.
You want to take the deal, Ms. Lopez?
Yes, I do, Your Honor.
All right, so with that stipulate to the face of the ticket as an actual factual basis for that responsibility the client have.
So stipulated, Your Honor.
Stipulate the probable cause for the dismissal of the other matter.
So stipulated, Your Honor.
Find your client responsible for the amended count of limited access 1 to 5 for the disregard of the red signal, amended from the disregard of the red signal and dismissing the other matter. When $125, when can you pay it, Ms. Lopez?
I can pay it Monday.
Okay, Monday is the 3rd of November. Pay it by November the 3rd. Pay it at any DivDat kiosk in the city of Detroit. I'm told you can upload the DivDat app to your phone, or you can come on down to the courthouse and pay it in person. Those are the 2 best ways I can tell you to pay it. If there's nothing further, Ms. Lopez, have a very good day. Best of luck to you.
You have a very good day, Your Honor. Thank you so much.
Yeah. All right, this is the city of Detroit versus Chinyu Okori, state of Michigan versus Chinyu Okori, case number SX 4594351. Appearance for the record, please.
Erica Harris, on behalf of the defendant, please state your name for the record.
Chinedu Okori.
Chinedu Okori. All right, good morning to you, sir. Date and time set for a pre-trial. No appearance. There hasn't been a request for an appointed attorney. I'm going to put you in the breakout room, Mr. Okori, with Ms. Harris. She's going to get you an updated offer. Keep in mind, you don't like the offer.
Thank you, sir.
Let us know what you want to do. Pass the matter.
Well, she gave me a call.
I'm getting the Cadillac of treatment up here today, Mr. Thomas.
As he's been getting.
Mr. Ogletree, are you there? Oh, you might be talking to this one. Yeah, the trial was let you wasn't. Here.
Oh, from yesterday.
Go get a call. I'm sorry.
I mean, I emailed.
So we don't have to ask for another.
I bumped into a lady on the elevator on the way here. She said, are you that guy that was telling us what to do? What's the instructions for the judge?
Oh, you mean the judge?
Yeah. I said, yes, ma'am. She said, I saw him on the news.
They said they can go coming out to the counter requesting you. I want Judge Perkins to have maybe other letters. They said they'd be mad. I mean, yeah, what? Maybe not. They don't want the other.
People in here don't want to be bothered.
coming down and requesting all of you.
Rodriguez. Where's Rodriguez? Is he me? We're just waiting on a lawyer.
Been in treatment for a while. Common Police Court's monitoring your counseling, so I don't think you need to have two courts monitoring it. So I'm going to mark you completed here. You'll just have to report to them.
All right, thank you, Your Honor.
Said in the report that you were under their supervision also. So your case here is completed. I'll almost have another review.
All right, thank you.
You're welcome. Anthony Giamarco, 24/7/24. Anthony Giamarco. All four hasn't appeared, still has some community service. See,
he was in service with us. He quit coming about a month and a half ago.
Okay. All right, I'll issue a warrant for his arrest for failure to appear today. James Hairston, 24/5/52. He's not appeared, and he hasn't done anything on this case that I can see. So there'll be a warrant for failure to appear today. Megan McCormick. 11/7/16 and 12/86 and 181. All right, so we've got fines and we've got community service still too, so.
Yeah, I have a payment I can make today also.
How much are you paying?
25.
Okay, how are you gonna get your community service done?
Well, I've started doing it, and I've been doing it on Thursdays in Parkerville, because that's the days that I have off.
I see you have done 2 days since the last time.
Yes, sir.
Okay. Well, I'll keep working on it. And what'd you say you were gonna pay on your time?
25.
25?
Yeah.
Okay, I'm gonna set you for December 1st. That's a Monday. December 1st, your next hearing, 9 o'clock. Go see the clerk, make your payment.
Is there any possible way I could do it on a Friday? I have drug court on Mondays.
December 5th then, I'll set it December 5th, Friday. Go see the clerk.
All right, thank you.
You're welcome. Raymond Miller, 23/184. He's an ODI, community service done, fine still owed. Okay, he is there. Yes. You need to make a payment today.
I mean, $50 payment yesterday morning.
Well, it showed up today, it got registered today, so you get credit for that. And community service is done. Okay. December 5th will be your next hearing.
Okay, thank you.
Get it done, and you can quit coming to these hearings. You are going to have about $230 left after today.
Okay.
We'll looks like. All right, David Moore, 25-135. RRS for counseling, this is an ODI. Okay. Says you were still positive for cocaine on a screen, so that's not good. They got your screens. So is he inpatient now or outpatient?
Yes.
Are you working?
Yeah, I brought money today to pay all the fines.
But you are working then?
Yes,
What do you do?
HVAC.
You own your own place or?
No, I'm working for Carpenter's HVAC.
Okay. Do they know you use cocaine?
They do now. That was,
I would think if I was an employer, I wouldn't want somebody going in other folks' houses if they're using cocaine. I think that's a big potential liability. So you got to get this squared away.
yes, sir.
Okay. So I'll let you remain. They haven't said they're recommending inpatient, but I got to think if he continues with these screens, inpatient's got to be the next step.
Most definitely.
So get your act together.
Yes, sir.
You got family?
Yeah.
Kids?
Yes.
Okay. Can't do it for yourself, do it for them. I just at Chesapeake High School and spoke yesterday, and we know this. I mean, drugs in our community, I've been here almost 40 years. When I first started, there was almost no drugs in our community. It's epidemic now. I mean, it's everywhere. Your kid, how old are your kids?
4 and 5.
Okay. Well, maybe they're not getting exposed to it yet, but believe me, pretty soon they're going to be out in the community. And I know from the guy that teaches addiction medicine at Marshall, and he does a lot of data collection. First age where people are exposed that are going into treatment that they report in their histories, 6th grade.
Wow.
6th grade. Well, but it makes sense. Like if you're using drugs and you've got them in your house and you got kids, I mean, I'm old, but I remember back, my parents still had guns and things like they thought I didn't know where they were. I knew where everything was in the house. If you got drugs in the house, your kids know where they are. And statistically, we know this too. There's no guarantee. You can live a clean life, never use anything, and your kids can still get in trouble and start using substances. But if you use, the chances that your kids are going to use go way up, dramatically go up. Do you want that for your kids?
No, sir, not at all.
Okay. Well, let's put it before maybe they haven't figured things out yet. They're 4 or 5, but pretty soon they're going to start figuring it out that what you're doing. And the odds that they're going to use, if they see you using or know that you use, are going to increase. And we don't want that, do we?
No, not at all.
And
I'll do better.
You've got a great chance. I mean, you got the resources here, people to help you. Everybody wants you to get clean. I'm sure other members of your family do. You got to make it work. Let's do it.
I'll do better.
Okay. All right. I'm gonna bring you back sooner.
Okay.
Let's do it. We will have court the day before Thanksgiving.
Okay.
The 26th, Wednesday. So I'm going to put you in for then. November 26th at 9 o'clock. And I want to see a good report then.
Yes, sir.
2 screens, okay?
Yes, sir.
Make it happen.
I will. Thank you.
Now, are you gonna pay anything on your fines today?
Yeah, we're up $250 for my fines today.
Okay, I'll put that down. Here, see the clerk. Jerry Morrison is here, 25,200. He's at ODP. Okay, I'm going to consider this a collection letter. It's a good report, and they think you've done well, that you've licked your problem, and you paid your fines off. So your file is marked completed. Congratulations, Mr. Morrison.
Thank you, Your Honor, for all you've done.
Thank you for taking advantage of the opportunity.
Have a good day.
Case is completed. Dustin Phelps. 15,720, 15,835. Still has a lot left, hasn't completed, hasn't appeared today, so it'll be a warrant issue for failure to appear. Okay, so that finishes review. We're going to start arraignments. Anyone out in the hall that has a new case needs to come in the courtroom because they're going to get called with the arraignments. Go ahead and have a seat. You're going to have a few instructions for you, and then we'll get started with the new cases. So these new cases are called arraignments, or if you missed a hearing before, you'll get called with the arraignments. The purpose of that is to make sure you understand what the charges are. You don't have to agree with them. I don't file the charges. They may be totally false. That's the prosecutor's job. They file the charges, and then they have to prove the charges. So you need to be aware of what you're charged with. So when your name, and sir, are you David Moore?
Yes, sir.
Mr. Moore, the state's filed a complaint alleging that on October 27th at 2:36 p.m. in Perry Township, you were operating the vehicle while you were under the influence of either alcohol, drugs, or some combination of those two things. The state's alleging that you submitted to a urine screen. Those get packaged and sent to a lab for testing, and it takes several weeks to get the results. So I don't have any results on your urine screen today. And the state's alleging there's one prior offense, but usually they give me a date. They didn't give me a date when the prior was, so that would be something they would have to prove. See a report in here from Kentucky Motor Vehicle saying that there was a DUI in Boyd County in July of this year. So that must be it. They didn't give me, on the complaint, usually they put the year of the offense. They didn't do that. I don't know if that's just a mistake. And the reason that's significant is under Ohio law, the more of these you get, the higher the penalties. The penalties go up. The more the second offense penalties are higher than first offense. So on a second offense, the maximum penalty is 6 months in jail, $1,625 fine, 5-year license suspension. That's the most you can get on a second. There is a minimum. The minimum is 10 days in jail, $525 fine, and a 1-year license suspension. There's also, if the vehicle was titled to you, and you're saying it wasn't titled to you, so it's required to be impounded if it was titled to you, it was titled to someone else, so that doesn't come into effect. So do you understand that charge?
Yes, sir.
And you've got 2 other charges. Driving with a suspended license, that's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. And speeding, driving 77 in a 55 zone, that's not jailable. It's a minor misdemeanor, maximum $250 fine. So you got 3 charges. Do you understand the 3 charges?
Yes,
Do you understand the rights I explained that you have?
yes,
How do you wish to plead?
not guilty.
You want a lawyer appointed to represent?
Yes.
You have a job?
No,
Do you have any income?
no.
I'll appoint Mr. Holt. I'm entering a not guilty plea for you. Mr. Holt is here. Get him in the courtroom.
Your Honor, I won't be here until like the middle of December.
That's fine, because he's got a urine screen, and it's going to be at least 9 to 10 weeks before we get the results back typically. So, and we need lawyers. Anybody out there wants to go to law school, we need you. We're running short of lawyers, so now's a good time to do it. Okay. Probably we can go 1st of January, really, realistically, before we would have any results back on the urine screen. What's your schedule then?
I will be here on the 5th, Your Honor.
Of January?
Yep.
Okay, let's set it for then. January 5th, this is a second offense also, allegedly a second offense. January 5th of 26 for a pretrial. Mr. Moore appeared on his own, so I'll let him sign a $2,000 signature bond. Not guilty plea is entered. He'll need to go get fingerprinted. So, Mr. Cooper's going to bring you a form that you'll have to take to the jail to get fingerprinted. You won't have to stay at the jail, but you have to go there and get fingerprinted, and then you can leave. Talk with Mr. Hall. Will be back here January 5th for your next hearing at 10 a.m.
Thank you.
You're welcome.
Table High versus Kenneth E. Hogan, number CRP 25678, AM EST.
All right, ma'am, who are you?
His manager.
Okay, well, you'll have to go back and sit down. Unless you're a lawyer, you can't hear with me. All right, you are Kenneth Cogan. Mr. Cogan, you've got 2 charges. 25678A and B. They're both failure to remit taxes charges. The A case alleges that on October the 16th of 2025, you failed to file withholdings for compensation as an employer. And that is an unclassified misdemeanor. The same thing was filed with a different statute. And the B case is failure to file a return or report required by the revised code for sales tax, also an unclassified misdemeanor. Do you understand these charges, Mr. Cody?
No.
Well, you're going to need to get a lawyer. Do you have
It's already been paid.
Okay, well, let's get the prosecutor in here and see if they still want to proceed. You got a receipt with you?
Yeah.
Okay.
I don't know nothing about it because I ain't been working anyway.
Morning, Your Honor. Good morning, Mr. Hill. This is Kenneth Cogan. He's got 2 charges with regard to not paying or filing the appropriate forms for taxes. He says that's been done. He has some documents to prove it. Just wondered if you know anything about this, if you still want to proceed with the case.
I do know about it. I spoke with the agent from the taxing authority last night, and the one charge is under 5747.07. which is titled Employers to File Return and Pay Withholding.
Yeah.
So the recommendation from the agent was that we would dismiss the other charge if he were to plead to this charge and receive a $100 fine in court costs.
That's what the prosecutor's recommending. Do you agree with that, Mr. Cogan, or you don't have to agree? How do you want to proceed?
Yeah, it'll be fine, I don't care.
All right, so we're going to dismiss the B case. 678B is dismissed. So you're pleading guilty to the A case, the failure to file the appropriate return on the withholding. You understand that?
No.
They're recommending a $100 fine.
That's fine.
All right, so I'll accept your guilty plea, impose a $100 fine, court costs on 678A. Can you pay that today?
Yeah.
Go see the clerk, pay it, and your case will be concluded. No probation.
All right, thank you.
Clerk's to the right, to the court.
State of Ohio versus Haley Bennett. Case number PRC 22-170 A, B, C, and D, PRD 22-1604 A and B, PRD 21-2280 A, B, C, and D, PRC 20-2061 A, B, and C.
And you're Kaylee Bennett.
Yes.
Okay, you had a review hearing on Monday. You missed that, and you're here today.
Yeah, I texted Roger Smith again. My son had hand, foot, and mouth, and he still wasn't able to go back to school on that day.
Okay.
Today was his first day back, so.
Well, I think these are all reviews, so they're not, there was no pre-trial or anything, I don't think. Let me check to make sure. Yeah. These are all reviews, so can you pay anything on your fines today, or can you still have some community service to do too?
I actually just paid $20 online. I know she said up front it won't be on there till Monday.
Yeah.
So I did $20 on there, and I may be able to do some more tomorrow. But I plan on coming to community service either tomorrow or Monday.
Okay. Mr. Cooper will be looking for you. I'm going to set your next hearing for November 26th, so that's the Wednesday before Thanksgiving.
Okay.
At 9 o'clock. November 26th.
Okay. Thank you.
You're free to go.
State of Ohio versus Tim Fortner, case number CRB 25709.
And you're Tim Fortner?
Yes, sir. Happy Halloween.
Mr. Fortner, you've been charged with a theft offense. The state's alleging that on October 27th, you purposely tried to defraud Walmart of property without their consent. It's a first-degree misdemeanor, maximum penalty, 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
You understand your rights?
Yes, sir.
How do you plead?
Not yet.
You want a lawyer appointed?
Yes, sir.
You have a job?
Yeah, I did. No, it's a long story, but not right now.
You don't have a job now?
No.
I think Mr. Morford represents him on the trial we have with him on Monday.
Okay. I'll appoint Mr. Morford in to represent you. He is on the docket today. Mr. Morford's here. So not guilty plea is entered.
Thank you.
He can sign a $1,000 signature bond. So he's on the docket for a trial this coming Monday.
Monday, yes, Judge.
Third.
I need to sign this.
Let's just put this for a pretrial then, for Monday. I'll set it for November 3rd, pretrial, 10 o'clock.
I'm good. Thank you, Your Honor.
You're welcome.
Your Honor, does he need fingerprinted on this one?
Was he fingerprinted on the other cases?
Yes.
They wanted to be per incident.
All right, so we're going to go to the jail, get fingerprinted. Mr. Cooper will give you the form and say.
Okay.
State of Ohio versus Monique Houston, case number CRB 25708.
Yes.
Your Nate Houston?
Yes.
Ms. Houston has alleged that October 27th, Fayette Township, he purposely tried to defraud Walmart of property without their consent. It's a first-degree misdemeanor. Action penalty, 6 months in jail, $1,000 fine.
Yes.
Do you understand the charge?
Yes.
How do you plead to it?
Not guilty.
And do you have any income?
Social Security.
I'll appoint Mr. Steyer to represent you. He is here, so we'll get him in the courtroom. Mr. Steyer, this is Monique Houston. It's shoplifting from Walmart case. She can sign $1,000 OR, so we need to go get fingerprinted.
Right here. And don't leave, I'll bring you a copy of that out in the lobby.
Now, she has a co-defendant with her. He has a trial set for Monday, so I set a pre-trial on his case for Monday. I don't know if you want.
I'm here Monday, so if we want to come back and do a pre-trial and kind of figure out where things are.
Okay, so that's the 3rd, November 3rd. For a pre-trial, 10 o'clock.
All right, thank you.
Sounds good.
So just wait.
Okay. He's bringing you a piece of paper.
Yeah, I'll talk to you about that as well.
Okay, we may have some more arraignments coming. They're working on paperwork, but that's all we have ready, so we're just going to start pre-trials now. So lawyers that have pre-trials that they want heard need to come in the courtroom, and so do their clients, and we need the prosecutor.
State of Ohio versus Joshua Turner, case number PRC 25625 A and B.
This is Mr. Polk's case.
No, I was just speaking Mr. Turner outside.
People out in the lobby, if you got a pre-trial, you need to be in the courtroom.
Approach, Your Honor.
Yes.
And they're off. No, we're not gonna do that. Court does call the case of Cross Street Apartments versus Hannah Schumacher.
Good afternoon, Your Honor. Norman Whitty, appearing on behalf of the plaintiff, Cross Street Apartments.
Your name? All right. And folks, where are we on this case?
Your Honor, if the court recalls, we had a first hearing on this over Zoom, and Ms. Schumacher raised an issue with trash collection at her apartment. And I've had a chance to talk to her and talk to my client, so I thought I'd give the court a brief update as to what the issue is.
All right.
And how we're hoping to proceed. The problem is that these are second floor apartments in a two-story building, and the building's lot line is the building's perimeter. So there's no place to put external trash cans. Historically, there have been trash cans on the sidewalk. That's been the way it has been for years and years and years. Recently, the city of Ypsilanti's code compliance people have been ticketing and refusing to allow the trash cans there. There's no place else to put them.
So the city of Ypsi's been ticketing
the owner and tenants for having trash cans on the sidewalk. The problem is we can't put it inside the building. This is one of those buildings where you open up the door, there's a vestibule big enough for the door swing, and then there's a staircase going up to the apartments. So we can't put it inside. There's no place off street to put it because my client doesn't own any place off street. So I think Ms. Schumacher is very reasonably saying, I don't want to drive 45 minutes to my parents' house to get rid of my trash. And I don't have a problem with her escrowing the rent. I'm getting up to speed on this now. What I want to do now is go back, read the city's ordinance and talk to them about this problem and try to find a resolution. So I think the best thing to do would be to kick this back a couple weeks to give me an opportunity to sit and talk to the city and see if we can't find a solution that works for the city, for my client, and for Ms. Schumacher, who absolutely should have a way to get rid of her trash on site.
What do you want to tell me? Thank you, counsel, for that.
I mean, I agree with pushing it back until the issue gets.
So that is very strange to me because I don't think in all the years I've been doing this that not having a place to put your trash has ever been an issue.
New one for me too.
I just have not heard of that. And when you were telling me at the first hearing, I'm thinking to myself, okay, what's this lady talking about? Thank you for getting that clarified because I wasn't sure when you were saying about the trash issue, and then we got the documents, and I'm still trying to. I'm like I don't understand. Like you just have no other place to put it.
Right.
So what have you been doing?
I've been driving it 45 miles one way to my parents' house to dispose of it properly.
That's not acceptable.
Bless your heart. Okay. Yeah, that's not. What other, are there other buildings around that?
And that's actually another part of the problem, is that there's another apartment building that my client doesn't own next door, and their tenants also tend to be putting things into any receptacles we have on the sidewalk. And so, you know,
do they have the same issue, you think, or?
I'm not sure about that. It's too early for me to know that.
Gotcha.
But, you know, from my standpoint, Your Honor, I totally understand where Ms. Schumacher's coming from. My client has been diligently trying to resolve the problem, but they haven't involved me. And as you know, attorneys have some other tools that maybe the manager doesn't have. So I'm hoping to sit down and see if I can't work a resolution of this.
And just one other question. So they've been ticketing the owner for the trash that's outside.
So for example, Jimmy John's is a tenant downstairs in the building, and they've historically had their trash cans outside for years and years. And now code compliance is saying you can't. So My client got a $200 ticket for Jimmy John's trash can sitting outside.
Because Jimmy John's is a tenant of your client.
Correct.
Right.
My client represents the owner.
So, okay. I'm just gonna ask this question out loud. I don't expect an answer because you probably, neither one of you probably know. How do you allow a restaurant to open without having looked at whether or not they have the ability to dispose of things? But you would have done that because that's the way they were doing it.
Well, so there's two answers. First of all, what Jimmy John's is doing now is they're keeping the trash cans inside and then putting it out around the collection times. But again, I mean, this building is an older building.
Yeah.
It probably predates the code. My position is these are grandfathered uses because it's been done like this since the beginning of time. But saying that and having code compliance agree with me, there's a long path to walk between here and there.
Oh, have you dealt with the city?
No, I'm sure
Yeah,
this is
it's a
going to
much
be fun.
longer walk than you probably are.
We're going to find out.
Just gonna say that. How much time do you?
I'd like to kick it a couple weeks and then come back by Zoom. I don't want Ms. Schumacher to have to come forward on these things because I don't think we have any factual disagreement between us. We're not going to need a trial. We're just going to need to find a solution.
Okay. And I'm just saying, if for whatever reason you don't get to where you need to be, if somehow or another you interplead the city, then I could foresee a settlement conference with you representing your client, Ms. Schumacher, in the city. Because
Your Honor, that's
right, she should not have to be doing that.
No, not at all.
All right. So I have 7th, 14th, 21st. Well, it'll be right before Thanksgiving. So which would be better for you, man? Why don't we?
I'm sorry, what was the date?
The 7th, the 14th, and the 21st.
Of November.
If you watch more football, you'd be able to follow right along. But anyway, go ahead.
The 14th.
14th would be.
Or is there a later date?
I have the 21st.
That's
You want
fine,
to do
Your Honor.
that?
I don't
Okay.
expect the city to be moving at the speed of lightning either, so.
Your expectations will probably be, well, never mind. I'll adjourn this to November 21st, 2025 at 3 p.m. That's an in-person hearing. However, what I will do is I will allow the parties to appear via Zoom, given the circumstances.
Appreciate it very much, Your Honor.
All right. Anything else, Ms. Schumacher?
There will be no judgment.
Ms. Schumacher? I do a lot of these hearings, okay? Right now, don't you even worry about that. I think the ultimate issue is to try to figure out how to solve this problem for you. All right. I mean, certainly for the landlord, but really solve the problem for you. You shouldn't have to be doing what you're doing.
Just to give Ms. Schumacher a little bit of comfort on that issue, she's been very reasonable to work with. She's putting her money in escrow. I don't need an order for escrow. She's going to give me the information on that. And just so you understand, the most likely outcome, if we work this out, would be something called a conditional dismissal. And that would provide that you would then pay the rent because you're satisfied with the situation and the case is dismissed. So I don't see, based on what I know now, any point at which I'm going to ask the judge to enter a judgment against you. I mean, things could change, but I don't see.
And now knowing what I know, even if he asked.
Get it.
All right. Okay. Ms. Schumacher, thank you. You have a great weekend.
Thank you.
Yes.
Okay. What?
He has one more, I guess I should say, in case you have.
What are you telling me?
Call the next one, we'll see if Mr. Reed puts his evidence.
Well, you know what? I passed one. Pleasant Lake. Is that council's?
No, that's not.
I didn't think so. So he has one. Okay, I get it. Just whole staff's been out of control. Linden Park Apartments versus Keith Young.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Linden Park Apartments.
Keith Young? Pardon? All right. Counsel, if you'd like to take a default, raise your right hand. solemnly swear affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
All right, go ahead, sir.
Your Honor, the following testimony is given on information believed formed after a reasonable inquiry into the facts of this case. There's currently rent to retain in the amount of $5,378.40 through today. Court costs in this matter are $159.15. Total amount to retain, $5,537.55. To the best, we did not ask for a money judgment in this case. To the best of my knowledge, the defendant is neither a minor, an incompetent, or in the military service, and Linden Park has kept the property suitable for use as a residential dwelling, if I may approach.
Yeah.
Thank you, sir.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Thank you, Your Honor.
All right, thank you, sir.
Have a great weekend.
You do the same. Willow Ridge Apartments versus Chandra Kumar Canadian. Give us a second.
Good afternoon, Your Honor, City Judge, on behalf of plaintiff.
The defendant present? Kanayan? Not checked in. This is their motion, I think.
Correct, Your Honor, they had indicated that they were gonna pay by today, they have not. At this time, we're requesting the writ just to be signed.
All right. I will grant that, them not appearing. I have it in my file, Mr. Katz, and I've signed that.
Okay, thank you.
All
And
right.
Your Honor, I think the escrow was released last week, is that correct?
That's what I have. Let me just check one thing. I do not have, well, I do have it closed out. So yes,
Okay,
it was
perfect.
sent. All right.
Okay, great, thank you very
Okay.
much, Your Honor. Have a good weekend.
Thank you. You too, sir.
Bye-bye.
Patrick Becker versus Daniel Wolf. Cynthia Wolf and Aaron Wolf.
Good afternoon, Your Honor, Patrick Becker.
All right, your name?
Daniel Wolf.
All right. And folks, where are we on this case?
We had an agreement to mutually terminate and dismiss the case if they had vacated the property by today. And
Yes.
unfortunately, I stopped by the property and that's not happening. So I was going to show up and ask for a default judgment against the two defendants who didn't show, and then the ability to try to work something out with Daniel Wolf.
Sir?
We are moving out tomorrow morning. We have movers scheduled at 9 o'clock. We tried getting them for today, couldn't do it.
A mover?
I'm sorry?
You tried to get a mover?
Yes.
And are they busy on Halloween? I don't know. Is that a thing? It might be. All right. Okay, so you're gonna move
Tomorrow morning, 9 o'clock is when the movers will be there.
to move out. Okay. And what you were requesting was a default as to the two non-appearing parties.
Correct.
And then you did not want me to issue a judgment as against hearing, because you said you were gonna try to work something out.
Yeah, so.
Well, tell me what you guys are trying to do, because.
Yeah, so what happened was rent started coming late for a few months, and we had a group meeting in early September where I had agreed to, again, mutually terminate and not charge them any money if they just moved out by the end of the month. They explained to me they were having logistical issues and finding a place to live, and I understood that. The property does have a detached garage. It's about 2,000 square feet, so it's large. And I told them, hey, put all your stuff in that garage. You can find a place to go. From what I understand, they're downsizing. Unfortunately, throughout the month of September, they really made no effort to move and didn't go anywhere. They also did not pay rent. I had to file with the court. In October, we went through the same thing. I told them the same thing, that they could have the exact same options if they paid rent. They did actually pay some back rent, which is great. Currently, there's an outstanding balance of $4,921.40. Unfortunately, I don't have a lot of faith that they do have movers scheduled. If Mr. Wolf could show me that they have something, or more importantly, they have a lease signed and they're moving somewhere, I think I'd be more comfortable.
He's holding something.
And I'd be happy to show you the mover schedule on my phone. Fantastic.
Oh, hold on.
I did not.
Just hold on. You're good.
So
he you have a new lease
Yes.
that starts what?
Tomorrow.
Tomorrow. Got it.
Got it. So I'm very, very, very good with that. So I guess what I would ask for is a judgment for the outstanding $4,921.40. I'm not going to worry about next month's rent. They can have tomorrow for free. And I'd be super happy.
I would argue that, Your Honor.
Pardon?
Mr. Becker has a deposit of $5,700 from us. Of that $5,700, there is rent owing in the amount of $3,900. But he can take from that security deposit. There's a delta of $1,800.
All right, let me. I got you. Can I ask you a question now?
Sure.
You use the word delta. I understand why you. Well, I don't understand. What did you do for a living?
Engineer.
Yeah, okay. That's why. All right. I mean, I understood what you meant, and I'm just like, all right.
Sorry.
Okay, so here, if he's got a lease and they're out tomorrow morning, you were going to give that free. Here's what. You got a security deposit, right? That would cover this amount? Is that,
It would.
It would? Okay, why don't I do this? And what I'm going to do is I'm going to decline to issue the judgment. I'm going to put this out 1 week.
Fair.
If they move, that's fine. And then if not, you can, if they move, then you can do the inspection, determine what's owed. If the security deposit is going to cover it, then I don't have to issue a judgment against them. You take the security deposit, delta and all, I guess. I don't know. Okay, I'm using it wrong. I'm a lawyer, didn't become an engineer because lawyers are never that exact. But oddly, my son is going to be an engineer, which is just like, well, yeah, well, my brother was. So I get where he gets it from, but it's like they're too on point. All right, so that's I think the way I'd like to handle it. Do it that way. Give him a chance to move out. I believe him that they can't get somebody today.
Sure.
For whatever the reason. So I'll adjourn it to November 7th, 2025 at 1 p.m. Now I'll tell both of you this, and maybe communicate with each other. If everything's all set, you've done the inspection, you've got enough to cover the back rent, and you guys would be satisfied in just taking that being done, they've moved out, everything's all set. I don't need you folks to appear here because then I can just dismiss the case. You wouldn't get a money judgment anyway, you'd be satisfied, everything be set. Fair enough?
Yeah, my biggest concern, Your Honor, is having son, having a judgment placed against him. He's moved out of the house several months ago. And
okay, no,
quite frankly, isn't a party to this whole situation that we're in now.
Your son, Aaron?
Yeah.
Okay, and so I'm not going to issue any judgment. If everything's taken care of, everybody's out, the security deposit gets covered. If there's a shortfall in any way, you guys work it out. If there's not, then get that portion returned. Then everybody.
We're good.
Okay. Works for me.
All righty. Thank you, guys.
Thank you, Your Honor.
Thank you, Your Honor.
Take care. David Sawolski versus Lisa Laro. Lisa Laro. And what about Maria? Okay. Your name, sir?
David Allen Sawolski, sir.
Okay. And there was supposed to be a written answer filed. How much is a non-payment of rent case? How much is you did file?
I wanted, I wanted a 1.5 month, $2,400 security deposit. And now she owes $3,200 in back rent because I
Hold
took
on a
over,
second.
what happened, sir, was I took over the property on September 26th. I bought it.
Okay, yes, I recall.
And so for her to stay there, I would want 1,600 per month. But that started on September 26th.
What was it before?
That was between her and the previous landlord.
So at what point did you give her notice that that was now her monthly rent?
Same date.
In writing?
No, sir. I knocked on the door and she answered it, and I told her that I want rent if she was willing to
On
pay.
what date did you do that?
September 26th.
And so then you were gonna charge 1,600 for October?
Yes, sir. If she paid it,
Then let me just ask you this. Why do you think you would not have to give her 30 days notice at minimum before you change any condition of her rental circumstance?
I'm not sure about that, sir.
Yeah, I can tell.
Yeah.
So
we had no agreement.
He came to my door and my daughter was there. Both of my daughters were there when he offered me the agreement and said he liked my dog. He said that he did not want to bother me for a down payment and that he would honor the $1,200 a month.
Did
I
you tell her
asked him
that?
for 24
No,
hours
sir.
to think about it, and I called him back and said, I agree.
Hold on a minute. Okay, but
No, sir.
so what are you claiming she owes?
Well, I for her to stay there, I wanted.
No.
Okay.
You filed this as a non-payment of rent case, saying
Yes.
that she hasn't paid rent.
Yes, sir.
And in that complaint,
Yep.
you basically indicated that, well, first of all, your complaint doesn't say anything about how much she owes at all. That's blank. Then you're saying that the rental rate is $1,600 per month. What I'm hearing is that is not true. And
I originally offered her, sir, 1,200 if she paid me that same day.
okay. Your complaint indicates there's nothing about a $1,200 offer. I don't know what this whole offer thing was, and I'm not necessarily, at least at this point, going to get into it. But there was no agreement between the parties. And assuming she's, say, a tenant at will, or that you would change a condition of her tenancy, that you gave her properly 30 days notice to up her rent. Yet you filed a complaint that says that the rental rate is $1,600. Frankly, sir, that's false.
Okay.
Then you don't say, you say no rent is due, right?
Which item is that, sir?
Pardon?
Which item would that be on the complaint?
Look on your complaint, paragraph 5, C and D.
Yeah,
There's nothing.
yes, sir, I overlooked that. I'm sorry.
Then, so if, as you're indicating, you purchased the premises, if she were a tenant there, what happened to her previous security deposit?
I don't know that I have no idea. I have no idea if she paid one.
I did pay one, that's why I feel.
Well, hold on, just hold on, ma'am, just take a breath, please. All right, how much did you pay as a security deposit?
It was 2,400.
Thank you. So if you purchase the premises you would have had, she was still in the unit. That means you purchased it subject to, I'll put it in legal terms, her leasehold estate. You then become her landlord, which means that then you are the one that is responsible for the holding of her security deposit. So where's her security deposit?
Well, I have no idea. The previous landlord told me she hadn't paid for 13 months. And-
I don't,
And he told me he had no
I don't,
security deposit.
I don't care what the previous landlord said.
Yeah.
But if you took subject to a leasehold estate, you would be required to figure out, I've got a tenant in there, have they paid a security deposit? Because then you're the one that would retain it, or he's got to return it to her. But I don't know how you ask her for another security deposit, because here's what would end up happening. Presumably, you've taken that $2,400 security deposit. That security deposit that is she previously paid, and any security deposit the tenant paid, is never the landlord's money. It belongs to the tenant. Which means that if, as you want in this complaint, for her to pay another $2,400, that means she would have theoretically a $4,800 security deposit. Even if I were to permit you to have the $1,600 rental rate, which I don't think can be imposed, you would only be able, 16 plus 8 is what, 24? The maximum amount of her security deposit could be 24, which means that you would be charging her twice the amount of a security deposit that legally you could require that she pay, which is going to subject you to damages. So that's where we are. Be honest with you, I think you bought this property without fully thinking through what you needed to do. You can't force this woman to do certain things and just automatically like appear at her door and claim that your rent has gone up by a third.
Yes, sir.
On my say so.
Yes, sir.
Where in the heck does the $4,000 come from that you're saying that she owed? Oh, that's the 1,600 that you're claiming, which is the improper rent plus the improper security deposit.
Yes, sir.
That's where comes up in the notice to quit?
Yes, sir. I wanted the 1.5 month security deposit plus the $1,600
You
a
need to
month.
go to the previous owner and find out where her money is. Because you're supposed to be the one now that's taking over a leasehold estate. You're the one that's supposed to retain it. And you're supposed to give her a notice of where you're retaining it.
Is she required, sir, to provide proof that she gave a security deposit to the previous landlord?
Yeah, I have my.
Hold on. You are requiring her to do some things and shifting the burden to her. I will call upon her to provide proof when it's necessary to provide proof, but I don't see anything in the beginning of this that you did that's right at all. Have you asked the previous landlord if he has her security deposit?
I did not, sir.
See? And so now what you want me to do is ask her whether or not she paid it. Quite frankly, I'm going to say this to you. Not sure what she wants to do. But what's going to end up happening is both you and the previous landlord are going to end up getting sued. So my question becomes, what do you want to do with this case?
Well, indeed, if she paid a security deposit to the previous landlord, and it looks like the security deposit I asked for is no good.
Well, but where is her money? The security deposit, did you hear what I said?
Yes, sir.
The security deposit belongs to the tenant and is to be held by the landlord, but it's her money.
Yeah.
So somebody needs to find it.
Okay. So I would need to contact the previous owner and see.
I don't know what you would need to do. All I'm telling you is somebody needs to find out where her money is.
Okay. I'll contact.
Moreover, the complaint, while you certainly could amend the complaint, the one thing you cannot amend is the notice that you sent to her. That notice has numbers in it that make no sense based upon what I've just told you. However, you did file a notice that on its face looks valid, so I can't necessarily dismiss this case on subject matter jurisdiction. However, if you wish to proceed with this, you need to understand that at the very end of the complaint, and pursuant to the court rules, that you're signing that complaint under penalty of perjury. That information has to be true. I don't think that any of this is true.
Okay.
So you can make your decision as to whether or not you want to proceed with this case or not.
Well, I think it might be better to dismiss it and pursue possession.
Well, because she asserted her rights?
Well, because if she put it.
Sir, get what you did.
Yeah.
You went to this woman, told her, based upon some representation that somebody else made about whether she's paid rent, not knowing the circumstances, not sure that was any of your business, but that okay, you took the place, didn't get her security deposit, asked her for another security deposit, and then try to increase her rent by a third. So here's what I'm gonna do, okay? I'm gonna adjourn this out 1 week. You think about it, you try to figure out, I'd suggest you go get an attorney. Because if she turns around and files a claim, you're gonna have a heck of a time. I'm just gonna be honest with you. But that's gonna be your call. I am not, because it's not in her interest, she's unrepresented by counsel. I'm not going to, and she's appeared, while you're moving to dismiss, I'm not granting your motion to dismiss at this time so that she can also pursue whatever remedies she may have if she chooses to do so. So I'm going to adjourn this out to November 7th, 2025 at 1 p.m. That will also be an in-person hearing. And I am not precluding the two of you having a conversation, provided you want to approach her as your equal. Thank you.
Thank you, sir.
Have a good day, ma'am.
1 p.m., November 7th.
1 p.m., November 7th.
Thank you.
Pleasant Lake Park versus Christopher Dennewick.
Good afternoon, Judge David Morris on behalf of Plaintiff Pleasant Lake Park LLC.
Your name, sir?
Christopher Genoviac.
Okay.
Sorry about that. I'm a little hurt today. Had to step out of the hall. I'm a recipient of SSDI at 100% since March of 2020. I just got some things I want to read. I don't know how protocol is around here, but I'm sure you'll tell me.
Well, it doesn't start with that.
Just start with this.
No, it doesn't.
I didn't hear you, I'm sorry.
It does not start that way.
Okay. All right, cool. Thanks for your time.
Judge, this is our second hearing on a non-payment of rent matter. Current rent to retain possession is $495 with fees of $75, costs of $110 for a total amount of $680. We have had some discussions, but no payments have been made, and parties were unsuccessful in finding settlement. I should note, Your Honor, that it appears an answer was filed with the court, but I did not receive a copy.
We'll get your copy.
Thank you.
All right, sir, what did you want to tell me?
Okay. So they're not doing maintenance to force the default. I've spoken with attorney, like one of those free attorneys that you call them, a number they give you on the form. I called one of them. They're like, yeah, you have like a brilliant retaliatory defense. I guess he's trying to do default and to quit. I guess I got the notice.
Do what?
I guess I'll just read what I have. I'll read what I have.
Well, let's not,
I don't want to jump the gun here, but I did. This kind of makes more sense. So they're not doing maintenance to force the default. They did not board up holes, but they set traps and they put poison outside the unit. Like when they should have just boarded up the holes. This creature, it's like a rodent. It's like nesting underneath my bedroom, like my bedroom floor. The skirting was never fully pulled back when he promised me that. We both saw this creature and he set traps that were too small. Like, and then he put poison outside the unit. He never pulled the skirting back to put poison on its nest. There are multiple entries around this unit. Please, let me continue. I'm really sorry for wasting your time. We really shouldn't be here.
ma'am,
So the skirting.
sir, you're not wasting my time. I'm getting paid.
Yes.
Go ahead.
Yes, sir. Well, I'm unemployed. I lost my job like a few weeks.
Okay, go
because
ahead
of
with your,
pain and
go
stuff.
ahead.
I know. I'm
Go
sorry.
ahead with your reading, please.
So the traps are too small. And Mr. Weasel, that's the name. That's the person trying to evict me right now. Is Mr. Weasel. Mr. Weasel and I both saw this rodent or creature, not at the same time, but it entered out of the lake. My rental unit is up against a small wooded line about 15 to 20 yards, and then there's a massive lake. So we've both seen this creature. It is fat. It is large. It's like a gopher. It's like a beaver rodent creature. So there's 10 points. There's 10 points. Almost done. So the traps were too small. He put, and we both saw it. We both know it's big. So I was trying to do walkarounds, and Mr. Weasel usually just sends his maintenance dude just to do the maintenance. And this maintenance gentleman is a kind man. He also lives in the park. And this gentleman also works for Mr. Weasel at the landscaping company. And let me point, for Mr. Weasel to send out this maintenance dude, he has to pay him double time. So he's a maintenance, maintenance man is an employee twice for Mr. Weasel. So we did schedule one walk around, but I was late returning from cleaning up a church festival. I spent 9 hours at a church festival on Monday morning. I was cleaning. We had.
So if they get rid of this animal, then
Yes, sir.
we're
Yes, Judge. Yes, sir.
all good.
We're all good. And let me just I have a couple more points. I know this is really going into banana
Do
town.
you know anything about the animal?
I did set up a trail cam.
Okay.
Okay.
Sir.
But I don't want to use that. I need to finish my points. So he never contacted me. He was on the property twice doing maintenance that wasn't completed, and he never contacted me when I was in the house.
Sir, I'm going to stop you.
I know. I'm sorry. This is
No, I'm going
I'm
to
just being-
stop you. That means stop talking.
Yes, Judge. Sorry.
Counsel, do you know anything about this animal?
We know of the idea of the animal.
Okay, I have no idea what that means.
We've heard of the issue, but my client has not set eyes on any animal. The animal at one time maybe was a mouse, and then a rat, and a cat, and then a beaver and a badger. And so my client knows nothing about any real animal. Traps were set, the skirt was tightened on the manufactured home. He has been out, or his management has been out on multiple occasions and has responded to all legitimate requests. The defendant.
Sir, you need to turn around and face the front and not wander.
I understand the defendant. I understand the defendant set up trail cams. We've received no footage. We've received no recording. We've received no audio file, no video. The defendant claimed over the phone that there's hours of critter noise every night. There are neighbors to the defendant.
Let me just stop you for a moment. Might it behoove your client to just,
Board up the holes that are super obvious. I'm sorry.
I don't know at
read it
what
out.
point I said I needed help with my sentence.
I know, I'm sorry. It's just,
Then you need to sit down and be quiet. Be quiet then if you can't sit.
we're cool. We're cool. We're cool. Yeah, stand still. Stand still. I know. I just gotta keep moving. I gotta keep moving. Sorry. I know. I'm sorry. I'm really sorry. I'm really sorry.
Might it behoove your client to just hire a company to come out and look and make a determination based upon evidence that they see as to whether or not this creature exists or not? Because quite frankly, if there's a company that goes out and they tell me, yes, there's an animal, then they can tell you how to eradicate it. If they say there's not an animal, we're going to be at a point that there's not an animal. And apparently not one that grows from a mouse to a beaver in no time at all. I've never heard of one in Michigan, but we'll see. All right. So how long, do you think your client would be interested in doing that, counsel?
Yes, Judge, I think my client would be happy to get an extermination company to come and write a report.
Yes. How long do you think it would take him to do that? Because I can put this over to the 7th and 14th. What would you? And I'm going to order escrow. So
Thank you, Judge. I think the 14th would be
a better thing.
better.
What does that mean? What does order escrow?
So I'll explain that in a moment.
Sorry.
I'm going to adjourn this to November 14th, 2025 at
2 p.m.
at 2 p.m. That will be an in-person hearing. How much is monthly rent? It's
Monthly rent is $1,250, Your Honor.
but portion of it is paid.
Correct. There was,
What's his portion? Do you have Section 8 or something like that, sir?
Just SSDI.
So you pay your full rent?
Yeah, I got, I'm not employed now because of the noises underneath my bed. Every night for 3.5 months. Like I can't sleep. I can't sleep
Okay,
at all.
your monthly rent is how much?
$1,250, Judge.
$1,250. All right, I'm gonna order escrow in the amount of $1,250. That is to be paid within 7 days of the date that it's ordinarily due.
I have.
You have to, and what I mean by escrow, sir, is you need to bring escrow to the court as funds, pay them to the court until this is resolved. When you bring it to the court to pay, the $1,200 must be in cash. We do not take checks or other forms of money. Understood?
Not understood. I have additional comments that I'm not sure if he just wants to like evict me in the future again. But the bathroom floor is sinking by like 1.5 inches. Like there's like a hole in the bathroom floor sinking. There's like a hole. And I've already made this maintenance request. And actually, so there's an animal, I found this out about 2 nights ago because I had missing food. There's an animal entering my living room through the vent. This is a trailer from the 80s. So like this past week I've had like, and I know exactly which vent it is. I've complained about that. So like there's now an animal entering my vent that I found out 2 days ago, and it's been eating my leftover food. It's going into my living room. This is a super old trailer, like massive. There's holes all around. He's already boarded up 10 feet on the main stairs. He's boarded up 20 feet on the south side, and I'm asking for like 8 to more 10 feet.
What is your next point?
So my next point is this trailer, I want to, so here's my official request. Judge, I want a state inspector. I want something from the state.
Then if you want
because
a
I think-
state inspector, you can call them and have it inspected.
Yeah, okay, so super. And then I'll find out about this private inspector in the future. Is that what I should be expecting? Because I want a state inspector.
I'm not gonna tell you to expect anything. You
Okay,
say
right.
you want it inspected.
I
you
want an
call and
inspector. I want
Find
a
out
state
whether or not Somebody's going to inspect it.
The
What's your
bath-
next point?
My next point is the bathroom floor is taking I think this unit should be condemned. It should,
Okay.
it should be pulled off the
We
property.
all have our thoughts and our process. I
Right.
don't know.
I'm going through that process right now. I'm just.
Okay,
with green
wonderful.
thumb, so, but this unit needs.
Is there
it's
another,
fairly-
is there another point?
That was Judge, I appreciate your
Is
time.
that it?
Yes, Judge.
Thank you.
Thank you,
Have,
Judge.
check the bathroom floor, please, counsel.
Yes, sir.
Check. Thank you, Judge. Thank you, Judge. Thank you for your service.
Chris, we'll be in touch about, we'll give you some notice before we come.
Don't, hey, come here. You walk out of here with respect, whether you like me or not, I don't care. You will not treat this courtroom that way. Am I understood?
Yes, Judge.
Now you may leave and you will leave in an orderly fashion. Go.
Yes, yes, Judge. I'm.
Go. Was that the end of that block? Thank God. All right, court's gonna stand in recess. We'll be back unless somebody wants to go right now. Yep, didn't have any volunteers. All right, thank you.
All right.
Have you seen it? Oh.
ABC and
And Mr. McNally, you're going to be representing Mr. Stevens?
Yes, Your Honor. I filed my notice of appearance today as well as other documents. This is one again, we would waive time. We would ask that both of these cases be continued to November 21st. And the purpose of that, Mr. Hield has offered a potential plea agreement that would resolve the felony up here. We don't have discovery yet, so I think I need that to properly advise.
And that can be produced before the 21st date?
I believe it can be, Your Honor, not just for the record, so that everyone understands where our position is. Our intention is to, unless there is evidence mitigating against this, our intention is to take this on to the grand jury. However, Mr. McCown, as he always is, was very convincing in convincing me that we could look at the evidence here before we send it to the grand jury, and if we find that there's a good reason to leave it here, we will.
Okay, so there's waiver of time constraints until November 21st, at least set for pretrial and preliminary hearing that day.
That's correct, Your Honor. Thank you.
You're welcome.
State of Ohio versus Gaines County, it's number CRB 25204.
And Mr. McDonald is representing Mr. Townsend and set for a pretrial today.
Yes, Your Honor. I believe the state is in agreement that we are going to dismiss these charges. Mr. Townsend's been ongoing with couples counseling, and his counselor has written him a letter which suggests that she thinks that they've ran their course and they're ready to be released.
Mr. Hugh.
I did receive a copy of that letter from Mr. McDonald. In fact, I can forward this to Your Honor if you want me to. It does indicate that they've been actively engaged in the counseling. Gage and Erica both have demonstrated receptiveness to therapy, and I feel that they will reach out for help in the future if needed. Both remain very family focused and invested in their children. So that was the goal of getting them to go to the counseling. Is Erica Townsend here?
No, our daughter broke her arm and she's getting her cast off this morning.
So Ms. Townsend originally, back in June, wanted us to drop the charges even then, but she agreed to go to the council. So if Mr. Townsend was able to pay the court costs today, we would be willing to dismiss the charges.
We're accepting of that, Your Honor.
All right, case will be nollied upon payment of court costs, and he can do that today. See the clerk, pay the costs, case is dismissed.
Thank you very much, Your Honor.
You're welcome.
State of Ohio versus Andrew Curry, Lawrence County Jail. Jesse Friend is on deck.
All right. I believe this is Snyder's case.
I'm not aware of an active case. Is it post-conviction matter?
Well,
Probation violation.
Oh, probation violation, okay.
yeah, there was a complaint for probation violation filed recently. Have you had a chance to talk?
I wasn't even aware that he was involved in this. I don't know the nature. Can I take a look at it and have it recalled, Your Honor?
Yes, I'll give you the files. Curry, sorry, call down, talk with you, then after that, Curry will have you back on teleconference and decide how we're gonna go.
State of Ohio versus Jesse Friend, 2535, Spencer Lloyd is on deck.
Mr. Brown was previously at Bethesda, and he left Bethesda. I believe we had common pleas as well as parole and maybe in this court.
Yeah, in this court, he has a extradition matter pending to Mason County, West Virginia, and he had posted a bond on that. He had a hearing set October 17th. In this court on the extradition did not appear, and also he had left treatment without court permission. So a warrant was issued, and it's my understanding he was apprehended by Mr. Sowers and brought to jail. So, and I have a note saying that Mason County, West Virginia still wants him, so that warrant in West Virginia remains active. So, I will revoke his previous bond on this matter. We're going to need Mr. Smith as his attorney. Is he going to be here today? I'm going to revoke his bond and change it to $100,000 cash or surety.
He is here.
Yeah, I hear that.
I drove all night to be here.
I got so upset after that game, I got the car and drove back.
Well, when I went to bed, they were ahead, and then I woke up this morning. What happened? Why? Really far south in second half, it looks like.
Who is this for?
This is Jesse Lee Friend.
Oh, yeah, yes.
He's got a Mason County warrant, and he's also got some matters in our county police court.
In front of Judge Ballard, correct. He took it off the active docket, and he also issued a bench warrant, Judge Cap, or
Okay, I'm changing
Judge
this
Ballard.
bond here to $100,000 cash for surety. It's my understanding I've been given the information Mason County still wants him, so I don't know how that's going to be balanced out. But I guess we'll let Judge Ballard make that decision if he's going to keep him or if he'll let him go back to Mason County. I understand the charges there are fairly serious.
I think he's going to keep him.
Okay.
But, yeah.
Well, do you have an idea when he's going to appear in common pleas?
I told Judge went to the inactive docket because he didn't show up, so
So he hadn't been there yet?
No, he hasn't been there yet, to my knowledge.
I'm going to suggest we go out about a month and come back maybe a little before.
Sure, yeah. I'm sure it's going to get on the docket very quickly.
How about the end of November, what's your schedule like?
I can do the very end of November, like,
24th or, I'm actually going to set a few cases. We'll have court on Wednesday, the 26th, if you want to try that, or the 24th is the Wednesday.
I could do the 26th. I know for sure without checking my calendar, I have nothing then.
All right, I'll set it for November 26th for pretrial, new bond, 100,000, cash or surety.
Thank you, Judge.
State of Ohio versus Spencer Lloyd, case number TRD 251332 A and B, and Freddie Sloan is on that.
The next defendant? Spencer Lloyd.
That's Mr. Holt's case. No, I'm sorry, wrong case.
I don't have a lawyer on it.
Yeah, wrong case. I was thinking of something else.
Sir, are you Spencer Lloyd? Can you hear me, Mr. Lloyd?
Yes.
Okay, and you are Spencer Lloyd?
Yes.
It's alleged that you missed a pretrial back in September the 12th. You missed the pretrial and the warrant got issued.
Your Honor, this is the case of that lawyer from Dayton.
Oh, okay, so now, all right, you have a felony that went on to the grand jury. The case here is going to go to the grand jury, so is there there's a hold over him, I'm assuming, from
Yes.
They're going to put, they set a bond, right? His lawyer says he's going to post.
Yes, Your Honor.
Okay, your lawyer was here today to deal with this, so what's happening is this traffic charge is going to be dismissed down to the common police to go with your felony. We're getting a lot of background noise, I don't know where that's coming from. So, your case here is going to go to the common police. Your lawyer says you're posting the bond on that, so if that's correct, then you should be getting out on the bond from common police court. The case here is dismissed.
All right.
Okay, that's all.
All right, thank you.
You're welcome.
State of Ohio versus Freddie Sloan, case number CRA 25710, CRB 23777, CRB 181253. Brianna Maynard is on that.
All right, and ma'am, you are Freddie Sloan.
Yes, sir.
Ms. Sloan, you have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed, to afford one, a right to bail, and to make the state prove the charge against you beyond a reasonable doubt. Do you understand those things?
Yes, sir.
You've got a new charge, and it's possession of cocaine is the charge. It's case number 25710. States alleging that on October 29th in Fayette Township, you knowingly obtained, possessed, or used cocaine. That's a felony of the 5th degree. Maximum penalty is a year in jail, $2,500 fine. Do you understand that charge?
Yes, sir.
Okay, then copy of that charge was faxed to the jail, so I don't know if you have it yet, but it should be there for you to get. There's an old charge I don't think you ever got arraigned on, so I'm gonna go ahead and arraign you on it now. I don't know how long it'll go forward. It's a domestic violence charge from 2023. Case number is 23777. And it alleges that if Fayette Township on December the 17th of 2023, you knowingly caused or tried to cause physical harm to Amber Sloan, and that Amber is a member of your family or household. That's a first degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Now, since is this Amber that's here today?
Yes, Your Honor. And if you want us to tell you what we're thinking on that.
Well, I just need to know if you're gonna go forward with that charge.
She doesn't want to go forward with that charge. So it's been 2 years, so. We'll not.
Okay, so, Ms. Sloan, you don't have to worry about the domestic violence, it's getting dismissed. Amber is here, she's asked the prosecutor to dismiss it since it's 2 years old, we're gonna do that. Then you've got another old case, 18-1253 was a theft offense, and you got convicted on it some time ago. And you had a review hearing March 20th of 23 that you failed to appear for and got a warrant outstanding. So that's still pending because it's showing that you did pay something on your fine, but you never finished paying. You still owe $100 and you owe 5 days of community service. So, do you understand the charges against you?
Yes, sir.
Do you have the money to hire a lawyer?
No, sir.
And Mr. Morford, I'll appoint you to represent Ms. Sloan. She has a new possession of cocaine charge, and she's got an old, I think it was a Walmart document that she never finished what she was ordered to do. That's the matters pending. What's the state's position on bond for Ms. Sloan?
Your Honor, I guess the only condition that we would, under which we would want her to be released from jail without a bond or with an OR bond at this point would be is if she would agree to go to treatment, be assessed for treatment, first of all. And if she would be accepted into a program, we would be agreeable to an OR bond.
So, I don't know if could you understand or hear that, Ms. Sloan?
No, sir. I'm sorry.
Prosecutor said he would agree to you getting released from jail on a signature bond, which means you don't have to have any cash to secure your appearance, if you would agree to go to treatment. If you won't agree to go to treatment, then they want a cash or surety bond to secure your appearance.
I can agree to do that.
Okay, what's your pay source?
I'm sorry, what?
How do you pay for medical treatment? Do you have a medical card?
Yes, sir.
Ohio? You have an Ohio Medicaid card?
Yes, sir.
Okay. Hometown is going to call and assess you. And I'm going to go ahead and do an order for her to be released to hometown for treatment with a $2,000 OR bond. Set, probably come back in a couple of weeks.
Please, Judge.
So that's going to be the 14th. Are you available the 14th?
Yes, Your Honor.
All right, we'll see you in a couple of weeks for a follow-up. So you're going to go to treatment. They're going to give you a report as to how you're doing. You gotta do what they tell you to do, how they tell you to do it, unless it's illegal or immoral. You don't have to do it, but otherwise, I expect you to do what they tell you. And follow and get a good report, because you're charged with a felony. So I know this is a lot, but I'll try to distill it down to small amount of information. Felonies mean you can go to the grand jury, you have to go to the grand jury for an indictment. They're so serious, you gotta be indicted by a grand jury first. Secondly, you can go to prison. That's the difference between felonies and misdemeanors. A felony, you can go to the prison, not to the local jail. So if you mess this up, you could get sent to prison. And it won't be me sending you, because you won't stay here in this court. You'll go to the main courthouse in Ironton, and one of the common police judges has the authority to send you on to prison. That's not a good option. That's not what you want to do.
No, it's not.
So, win-win, get clean, take advantage of this opportunity, and don't have a felony on your record, because if you're successful, complete treatment, I believe the prosecutor probably would agree to dismiss your charge down the road. But that's not going to be like in 2 weeks or 2 months. Probably a year from now, if you're successful, then they may dismiss your case. So you got to really do this. Not just fake like you're going to do it to get it dismissed. You got to really do it and get clean.
Yes, sir.
Okay, is that what you want to do? Yes?
And I'll leave it for a year or something?
Yeah, you're going from the jail to treatment.
Okay.
And the other options aren't very good. You can stay in jail and get sent to the grand jury and get indicted, and then go face one of the common police judges and try to convince them of what you want to happen. But the best thing you can do, I think, logically, take advantage of this treatment. If you had to pay for it yourself, it's thousands of dollars. And tell you the truth, I don't know how much longer it's going to be available. I mean, you're getting right in on the tail end of it. It's probably, a lot of it's going to go away here pretty quickly. So take advantage of it, get clean. I'm sure your family is still here.
I am.
Do I get an amen from you?
Amen. And Butch, thank you so much.
So we got your family, I assume your family.
Mom and sister.
Mom and sister. They're amen on what I'm saying. So they want you to do it. Mr. Morford wants you to do it. I don't want you to do it. But you know who's most important? Do you want to do it? Do you want to do it? Here's the other thing I said at Chesapeake High School. And it applies to adults too, but especially applies to kids. Who you hang out with is so important. If you're hanging out with people using drugs, guess what? You're going to use drugs. So you may have to make some changes. If you want to change your life, you can't say, well, I'm going to get clean and then go pal around and hang out and run around with people that are using drugs. It's not going to work. Okay, well, I don't know that. I'm just going from past experience. And if you've got a boyfriend that's using drugs, you're not going to quit using drugs. Or if you're a male and you got a girlfriend and you try to get clean and you got a girlfriend that's using drugs, guess what? You're going to keep using drugs eventually. So, you got to make some changes. Make some changes. It's time. How old are you now, Freddie? I've had you for a while. 46. Okay, you're a full-grown woman, even today's day. 50 years ago, that was an old woman. Now, when you're 30, they act like you're 13. So 46 is a way full-grown woman. It's time to straighten out and do what you need to do for your family's sake. Amen? I need an amen over here. Okay. I'll see you on November the 14th, hopefully with a good report.
Thank you.
You're welcome.
Thank you.
You're welcome.
Thank you, Your Honor. Thank you.
State of Ohio versus Brianna Maynard, case number CRB 25548. And Edward Markle, Emery Markle, we call that. Brianna Maynard.
All right, this is Mr. Steyer's case. It's set for a free trial today.
Your Honor, Ms. Maynard is, she has a misdemeanor case pending here. It's my understanding that she is due to be sentenced sometime in the next week or so in common police courts to prison time. This is a case, I think the victim wasn't all that interested in pursuing domestic violence. The state has indicated that since she's going to be in jail anyway because of the matter of common police, they'd like to continue this out past her sentencing, and the intent is probably knowledge of that. Okay. When do you go back for common police, man?
What is that, sorry?
When do you go back to common police court?
I already took a deal, so I'm just waiting on sentencing.
Wednesday. Wednesday. So
Probably Wednesday.
Okay, if we can come back fairly soon after that, 'cause we'll haul her up and get transported once she's sentenced.
Okay, so that's, we can do it the 7th if you're available then. November 7th.
Let's set it down.
All right, and I'm setting your next hearing for a week from today, November 7th.
Okay, thank you.
Free trial.
8.120 under the supervision of Sarah Sallin to represent both Deborah Palmer and April Palmer in this matter.
Good afternoon, Ms. Allen, and permission to practice is granted.
Good afternoon, Judge.
All right, you two, what are we doing on this one?
It's a termination
Mr. Freeman,
case.
you gotta, these guys, and
I know, it's a termination case, Your Honor. Their lease is long expired. We're asking for judgment of possession only.
all right, and what do you have to say, counsel?
We're seeking a short adjournment in order to file our answer next week.
That was last week.
Yeah, I thought, how long have you been representing the defendant?
We received the case in late last week, but we actually haven't received the filing documents from the plaintiff's counsel. We reached out twice last week and didn't receive anything. So we got the complaint and the summons from the courthouse itself. We still don't have an official notice to quit. So the grounds of the termination are unclear to us.
Understanding is there's no lease or the lease expired?
Long expired.
So you're saying you didn't get the notice?
No, we never received any of the filings from the plaintiff's counsel, though they reached out twice in the past week. So we've essentially done 90% of the legal work on the answer, but the actual substance of the legal claim, we didn't know really until we spoke to the client. Even then, it's not obviously clear.
That's gotta be a University of Michigan thing. I don't know how you do 90% of the legal work on something you don't know about.
Yeah.
I do. We didn't do things that way in Maryland, but that's okay.
Your Honor,
That's okay. They're teaching a new kind of law.
This is just a straightforward term.
I know.
There's nothing complicated about it. And
Well, except the counsel's claiming he doesn't have the documents, which I'm a bit confused about because I received October 24th, a week ago. And then you say ultimately you got them from the courthouse, but you didn't get the notice?
No, we didn't get any of the attachments. So we got the one-page complaint and the summons, but the notice to quit was not attached.
I'm gonna trust that he didn't get it, and I'll let you look at it. I'll give him 1 week to take a look. I'll adjourn it to November 2025.
All right, thank you, Your Honor.
Time,
Thank you, Your Honor.
2 PM. All right, thank you.
Thank you very much. Appreciate it.
Thank you, Judge.
That is it. That's an in-person hearing. And Melanie, you didn't say anything. What's up?
I was letting him take the reins for.
Oh, okay. All right, you probably didn't think a judge would just say, hey, what's up? All right, have a good weekend, you guys.
Thank you. Have a good one.
Barnes and Barnes versus Rosa Bannock.
Your Honor, Ellis Friedman on behalf of.
Your name?
Panic.
All right. And where are we on this case?
In talking with Ms. Bannock, it sounds like she's filed a 539. Is that accurate?
You mean
The Hawk form?
the rental assistance? She did.
Okay.
And so I think she's entitled to another adjournment in any event. You don't have an answer from them yet?
Not yet. I was waiting for an offer letter from my boss and then.
Pardon?
I said I was waiting for an offer letter from my boss and never gave it to me. So I ended up sending my first pay stub and my time card. Because he.
Oh, you needed to supply some
Yeah.
type of, and so you didn't get the information from your employer that you thought you were gonna get, so you sent what you could.
Yeah.
Okay, I got you.
Yeah. And
All
I
right.
didn't want to sign the COD just yet because I didn't want to be ineligible for help. So I don't know how it works, to be honest.
Okay, you said a lot of things there.
Sorry.
We offered her a
That means-
COD, but it hasn't been fulfilled yet.
It has, yeah, I haven't signed it.
You haven't signed it because you're trying to figure.
Yeah, I asked.
Okay,
So,
all right, that's,
plus the payment was supposed to be Wednesday, which I was kind of unaware, and they sent it to me yesterday. I got sent the COD yesterday, and the payment was supposed to be the day before yesterday. Yeah,
so the dates of payments need to, well, let me ask you this. The payment that would have been due under the COD, do you have that or?
I don't get paid until next week, next Monday, to be honest. And I thought I was gonna be able to pull the money out because the app that the thing that they use offers that you can pull money out. And I thought I'd be able to pull more than I thought, but I'm not.
I gotcha.
Yeah.
So let me just try to put it this way in a nutshell. The COD is not really objectionable to you. You're just trying to figure out everything.
Yeah.
And the monies you thought would be available aren't available, but you'll have something come Monday.
Yeah. My paycheck.
I got you.
And then she's also said that the funds for Hawk are not available until November to pay November's rent on time, and they'll pay their arrears.
The people at Hawk told you that?
That's what I was told last Monday.
Oh,
Yeah.
that means
Have funds for October.
okay.
Yeah, I don't know.
No, it's okay. It's just that some of the funding's been a little bit weird, but if they told you that you're gonna get it.
Yeah, I guess that's what they, everybody?
Pardon?
I guess that's what they've been telling everybody.
Well, maybe, but that's not,
I don't know how it works.
well, I used to know. And then all right, here's what I'm gonna do.
Sorry.
Let's do it this way.
There's a lot of things I've been trying to navigate lately. Like I just recently was a victim of domestic violence, and now I have to navigate that, being a single mom, and I don't have anyone out here. So all of this is just coming at me at once. So I'm sorry.
No, it's okay. And let me ask you this, are you, I'll adjourn it to November 7th, 2025 at what time?
2 p.m.
At 2 p.m. in person. And you brought up something, and just to explore, there isn't an issue of child support, is there?
No,
No? Okay.
I'm
All
not for child support because he can't hold a job. Which you will see me on Monday, by the way. So
okay.
you'll understand
Right,
more on
I guess I'll
Monday.
say I look forward to it.
Yes.
But if you wanted, so that you know, if you wanted to pursue that, whether or not he's holding a job or not does not necessarily stop somebody's obligation to pay for their child. So I will tell you that. we have a program here through our friend of the court set up through this landlord tenant case where we provide assistance and a connect for you to talk to the people at the front of the court. We can give them your information so you can begin that process. If you would like not to do it, you can make your own choices, but we want to make sure that you can explore all options that you can.
Okay, I mean, you can still give me the information.
All right, well, what it is, we'll get your email. We'll send that off to the front of the court and they'll contact you.
Okay.
All right, fair enough?
Yes.
All right,
Thank you,
sounds
Your Honor.
good. November 7th, 2 PM. All right, thank you. Court does call the case of Burns and Burns versus Annette Brown.
I'm going to move to dismiss that, Your Honor.
All right, very good.
She made that payment, that big payment.
That she made it?
Yep.
All right, case is dismissed. Wonderful. Take care. Court calls case of Stephen Amanda Raines.
Fellow treatment for the plaintiff.
No, I was gonna say as he was walking up, I said, he is not Amanda Rain. All right. Your name, ma'am? All right. Nation case, where are we?
I have been unable to make any headway with Ms. Raines. Just a termination of tenancy, straightforward. She doesn't have a lease, not paying rent.
All right, ma'am, what's your position on this?
Good afternoon, Judge Simpson. So what happened was, thank you so much for allowing me to come back today because I was here last Friday. And because I got served a few days before last Friday, and I wanted to take the time to find legal counsel. And I reached out to U of M student legal counsel and left
The
messages.
clinical
Yeah.
program? Yeah.
Back, and then I called Ypsilanti legal counsel like 10 times and I couldn't get through there. Like it said unavailable to take calls due to high call volume or something over and over again.
Are you talking about legal services
Yeah.
over at Nipsey? Okay.
So I couldn't get any legal advice. So I just like trying to read things online. So this is kind of the breakdown. Stefan and I were together I lived in that home for over 5 years. I always paid my rent. I paid half the bills. I paid for so much of the home. And we were going through a breakup, which basically turned us into a roommate situation. And I always paid my rent. And then he asked me for the rent and I said, use it out of my rent credit because every year he kept my rent credits. And I asked him for it and he would never.
Your rent credit, I don't.
Like taxes and stuff, because I paid half the rent. I never got a rent credit from him. And I said, okay, can you use the rent credits for my taxes towards this rent payment? And he said, done. So I took that as a yes. Well, I was looking for a place to live and I couldn't find anything. And I went from working a temporary job to not having a job to trying to find another job. And I said, I have $800 for you for the last 2 months rent. And I have it on text message. And he said, no, I don't want it. He goes, I want to stick to a time frame because he served me paperwork. And he's not the landlord. He is the landlord's son. And he does not have a current lease. His lease expired in 2011. And his mother said she would never give me a lease because we were in a relationship. So I am not sure what to do. I just received a new position with a new company and I just need time to move. And now it's on my record that I have an eviction. So I'm looking and it's going to be kind of hard with this eviction on there because I think that landlords can see that. And
well, I don't. Okay, go ahead.
I'm sorry. And it's just that I offered the money and he sent me a notice saying for non-payment of rent and I offered the rent and he declined it. And I have that, but
No, I got you.
my cell phone in, so it's all on my cell.
Couple of things. I'm not sure as I look at this. There's gonna be, I doubt you did, Mr. Friedman. But oh boy. Have you looked closely at the notice to vacate?
I can.
Couple of things. One, because we called it a 30-day, but theoretically it's a 1 month notice. I mean, certainly there's a day issue, but the basis for the notification to vacate is for non-payment of rent for July. I don't know, did you get you have your copy, Mr. Fisher?
Yes, I have my copy, Judge.
You seen it? You got it?
Yeah.
So I'm not sure if this, I mean, read one way, this is a non-payment notice, but it would be defective in that regard. And read another way, if it's a termination notice, you can't have the basis for the termination to be non-payment of rent. If the basis for termination is that she just doesn't have a lease. So I think there's a problem with the notice. I'd have to look at that a little bit more closely, but I'm not sure that this notice is proper in its form to invoke the jurisdiction of the court. It'd be my concern because of the language on it, but also because of the language this notice does not contain, which is required.
Well, obviously,
be on the scale for.
Yeah, obviously, we didn't draft it.
Yeah, well, I was making that clear at the beginning that you did not. The other concern that I have, and she raises a point, and it's been raised before, but I never had to particularly rule on it. In these cohabitation situations where rent is being paid in part, there have been claims about the rent credit. And I really do not feel like looking into everybody's taxes. I don't feel like any of that. But if in the filing of her taxes, she does not claim a rent credit or doesn't use what she's paid, yet in the filing of his taxes, he did, theoretically, that money, and again, I haven't ruled on it, and people would have, I mean, it's been raised, but I haven't had to rule on it. She would be entitled to that credit, is particularly if she's asking for that credit to go against her rental obligation.
Well, I think that the
5 years So I
Pardon?
haven't received my rent credit in 5 years that I asked for.
Well, Your Honor, hang on.
Well, the 5 years may be a bit much, but let me put it this way. I hear you, but I don't know that one goes back 5 years saying I didn't, because I'm not going to go into every little bit of the arrangement that the two of you had. I'm just not going to do that.
Mike, I think my client would like to just would like to address the court for
Yes, sir.
a moment here.
Yes, sir. How you doing, sir? Fan of your YouTube. She received a couple credits for a couple years. I am happy to also not ask for restitution for previous months. I just want her to leave my home.
Restitution
or any back rent.
She hasn't paid in months, so we're not going to go down that road.
Yeah, I mean, all right. I'm just gonna say this. You two were together for 5 years, right? Somehow or another, you had some relationship. The relationship breaks off, and now one person wants the other party out. That's really what we're dealing with here. And now everybody's trying to bring these legal things in where that wasn't the issue before. Somehow or another, however you guys worked yourself into a relationship, you got to work yourself out of it and treat each other kindly and try to get out of it. She wants to go. I don't think she wants to stay. It's going to be an issue of time for her, is what I'm hearing.
And I offered her I asked her how much time she needed, and she said she wanted to address the court.
That's fine. And I get that she may want to address the court because you're representing him, and she's probably a whole lot, not a whole lot of trust now between the two of you. So
no, certainly not.
That's right. And I don't trust either one of you. So just saying that. All right. So I think I'd have to adjourn it out because I think number one, the notice issue needs to be looked at, because I need to look at it because I'm not sure that the jurisdiction of the court's been invoked.
I understand. Obviously, I'm going to send out another notice today.
Yes. So you understand that, ma'am? No. Okay. So that in order, without getting too technical, the district court is a statutory court. The only way I have jurisdiction over certain claims is that certain things have to happen for the court to have jurisdiction. For me to have jurisdiction over this landlord-tenant matter outside of venue that it resides in the area that I oversee, is that the notice has to be correct, the notice to quit. That's what invokes the jurisdiction of the court. On the face of it, I will be honest, I don't think that this notice does, and I don't think I have jurisdiction. If I don't have jurisdiction, then the only thing that I can do with the case is dismiss it. I'm not prepared in looking at it to necessarily make that ruling when I see it right now. But I'm going to adjourn it out a week. When we come back, I may make the ruling that I don't have jurisdiction. If I make that ruling, it's dismissed. What Mr. Friedman is indicating is two things. First of all, he did not prepare that notice, and he wants it clear. And secondly, that he will be sending out a new notice to you, giving that 30-day period at this point. That would not waive any claims that you can make or anything along those lines. It's more a procedural issue than anything else. Okay. Did I confuse you more by saying what I said? Okay. All right, guys.
Thank you, Your Honor.
So I'll adjourn this to November 7th, 2025 at 2 p.m. Yes, ma'am.
Because I just started a new job, I had to take off today, and it was my first week. Is it possible that I could do a Zoom call?
You can do a request, and we will strongly consider it given the circumstances.
Okay.
All right.
All right, thank you.
Thank you. Court calls the case of Glen Oaks Cooperative versus Kaylee Andrews. No, she's here. She is.
That's a dismissal.
She's trying to make her way up here. Hello.
Good afternoon. How are you? I'm Kelly Andrews.
Did I say the wrong name?
No, you said the right name. Wrong pronunciation.
Anyway.
Wow. 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 No, you said it right, but Judge, you mispronounced my name.
Okay.
Judge, you called me out my name. You know, you see what she did now?
You called me late for lunch before, so I just want to make just make
Well,
Kelly?
the good news is she has made substantial payments and we're moving to dismiss.
Kelly, do you have any objection to that?
No, sir.
All right, very good. This case is dismissed.
Thank
You have a blessed weekend.
Can I approach for a second?
Yes, sir. Okay, well, we'll see. You never bring me anything easy. All right. I said, you never bring me anything easy. All right. Oh. Yeah. Okay, we're back on the record. Court does call the case of our management versus Bobcat Bonnies and Matthew Bouchard.
Alice Friedman for the plaintiff, Your Honor.
They're not here. All right.
They never appeared, Your Honor. It was and we took a default on the record approximately a year ago.
And I've been trying to work it out. We set this hearing for them to object. At this point, although the terms are placed in, no judgment entered, I don't need additional proofs at this point, but given all of that, the court will enter the judgment.
Thank you, Your Honor.
The parties having had notice. So I will issue a judgment by default for possession. Redemption amount inclusive of costs in the amount of $27,069.70. However, I'll enter it in that amount with the writ issue in 10 days.
They have long since vacated.
Yes, okay.
Thank you.
Thank you. Arbor Woods versus Shakiri Lee.
Good afternoon, Your Honor. Casey Madden, P87729 on behalf of the plaintiff.
Shakiri Lee. She is not checked in, and this is based upon her motion. This is a writ hearing. Yes, it is. And her not appearing, are you requesting that the writ issue?
Yes, Your Honor, we are requesting that the writ issue. We received notice of this hearing yesterday. We did not receive a copy of the motion that was filed by the defendant, if filed.
Let me just make sure it wasn't, was this my setting? It doesn't seem like it would be, but I don't see a motion from her.
Your Honor, we did file first the order of eviction with the court, and then we had filed an amended order of eviction because the payment had.
That's correct. That may be why I did it this way. Yeah, because she did not file a motion. The court set it based upon what had transpired in the case. But what I know why, because the number went to a different amount. Yes. So what I will do is we have the amended application in order for eviction. And I've signed it.
Thank you, Your Honor.
Thank you. Arbor Woods versus Ellen Patterson.
Casey Madsen for the plaintiff.
Hello.
Hi.
What's your name?
Marty.
Pardon?
Marty, Marti, Cole, Cole. I'm the daughter.
You're the daughter. Okay. And you reside at the premises?
Yes.
This is Miss Patterson?
Yes, I do.
Okay.
My mom passed away in August.
Miss Patterson did. That's right. I now recall when we read it. All right, where are we on this case then?
Your Honor, there is still a balance due and owing. We are requesting entry of a judgment today. But Miss Mari has failed to fill out a tenancy application and be approved for such. I do believe an occupancy application was filled out. However, in order to, continue the tenancy, she would need to fill out an application for tenancy within the community, which has not been done at this point.
So when was I supposed to fill that out? Because I thought that they were giving me till the end of November to vacate the premises. Nobody contacted me.
You're gonna vacate.
Yeah, I didn't want to stay past the end of November. I just wanted to the end of November to vacate the premises. That's all.
Your Honor, she did request until the end of November. However, my client was not agreeable to give until the end of November, so we would ask for a judgment at this point with 10 days.
When did your mom pass away?
August 14th.
Of this year.
She did.
So you just been scrambling since.
Yeah, I don't know what's going on with her beneficiary not paying her rent for the time of me being there, but
Right, that's what you said the last time, that there was supposed to. They haven't paid it and you haven't been able, this person that's receiving the funds
has not done anything. So, and I'm not in contact with her, my brother, my sister. So, yeah. So, I mean, I don't know. In 10 days, that's not enough time.
You just don't.
Let
me ask you this. Okay. I'm going to grant them a judgment because I think it's appropriate in the case for possession. How much time are you really looking at that? If I said you got to get out, what's the soonest you could do it?
November 30th. Maybe a few days before, but I mean, I need that much time because I just started back working. So I do have a security deposit I got to pay when I move. So I have to say.
I got you. I hear you.
I mean, we would object to that. This case was filed in September, so she's had at least 30 days already to.
Yeah, and I just started working this month.
It's her brother.
In October.
Okay, hold on a second. Ms. Matson, what's your name?
Yeah, we haven't spoken.
Who is he?
My brother.
Yeah, you can come on up, as long as y'all ain't gonna fight.
I don't even know what he's doing here, but yeah, whatever.
All right, so what's your name?
My name is John Covington Jr.
All right, so what?
So I'm Ellen's son. I'm here to kind of give a basic background to this situation. She has been at my mother's house for over a year now. With
who has?
Me.
Okay.
Not being able to keep employment. It also already has had 2 evictions by my mother as far as paperwork when she's been at the home. I have talked to her.
So why does this matter to me?
So I've talked to Arbor Woods of the situation of getting my mother's things out to put in my auntie's.
Oh no, that's what this is about. See, him and my sister have came over with a big U-Haul trying to put me and my kids out so they could remove all the furniture and take it. Those are my mom's possessions and she did not leave them to him or to one person. And since I'm there, they gonna come and take everything so me and my kids can sit on the floor. Like, that's not right. And I would never do that to them either. When I leave, I'm taking everything with me. Period. And I'm moving. So why would he think that everything would be outside or that he could take it to my aunt's house? Me and my kids are using it as of now because we are staying there. And like he said, we've been there for a year. We have.
Upon that situation, sir, it was to the point that the eviction had came out. That was the only reason we were over there to try to move the things. Upon that point, as you can, and there are lawyers right there, I'm pretty sure she can talk to who she's representing. She has changed the locks. Only reason I was at the house is I have a key to the house. I have,
and I changed the lock because him, my sister, and my aunt tried to come over and put me out, and they tried to remove everything out of the house so we can have to sit on the floor.
I don't need to put any.
How are you removing the furniture, John, when me and my kids are sitting on it? How are you removing everything out the house and taking it to Pam's house when me and my kids are there using it? I would never do that to you. Shut up. What things? You don't have no thing. Listen, 2 officers came over. There was officers.
Be right with you in a moment.
I had to call the police on them because they came over trying to put me and my kids out and remove everything. So the officers told him, my aunt and my sister, that they cannot come over there and remove nothing.
Okay, but hold on a minute.
All I wanted was my stuff, which is.
You don't have nothing. Your clothes, I gave them to you when the officer was there, and he said that's it, and he told you not to come back.
All right, so when you guys pulled up to the building.
No, I was here. I didn't.
Just stop. Okay. Don't interrupt me. You can interrupt him all you want.
I'm sorry.
When you pulled up to the building, it said 14A District Court. Walked in here to District Court. I am not a probate court. I am not a family court.
Correct.
So all of this stuff that you guys are talking about, fine and dandy. I can't do anything about that.
I'm here to figure out the day as far as when she has to be out, so we can.
Well, frankly, sir, you don't have any interest in this and haven't appeared until today. So I don't.
I've been at work.
Well, I don't care where you were. I'm just saying I'm on my 3rd hearing. And she's appeared at every hearing. And you haven't been here. And now you come in here and talking about you want to know what date. I'll give the date because publicly I will that everything's going to happen. But everything else is up to you guys.
No, I understand.
Counsel, how much is owing?
Your Honor, rent to retain is $3,140.96. Cost of $186.00 for a total of $3,326.96. We would ask for that writ to issue after 10 days. This is a rented home. They don't have any interest in the home itself.
Got it. What I'm going to do is I'm going to find after finding no tribal issue as to the amount of rent that's due. I'm going to judgment for possession to the landlord. The normal writ date would be the 10th. I am going to extend it a bit, ma'am. I'm not going to give you the 30 days to do it. I'm going to extend it to the 14th. And at that point, the landlord can take it. So writ to issue November 14th or thereafter, 2025. All right. Thank you. I might want to check that hallway, Alan. I'm walking along and having a great day. And then all of a sudden, not. Let's try this case. Northville Crossing versus Barbara Bargo.
Casey Matson on behalf of plaintiff.
State your name.
Barbara Vargo.
I'm her husband, Michael Fargo. See, when he says I'm her husband, he says that proudly every time he appears. All right. Okay. Where are we on this case?
Your Honor, I have rent to retain of $2,016.44, court costs of $190, for a total of $2,206.44. Your Honor, I do believe this is the third hearing, so at this time we would request a judgment.
Right, but yeah, I get that you're requesting that. Where are you folks with everything?
Of course, the veterans have been slow responding. Drika Jacob at Washington's VA is working from home actually, and not as many hours. So she finally earlier this week got me information on how to apply online to a different fund through the VA, Emergency Assistant Trust Fund. And then I couldn't figure out how to apply for it online. So anyways, I eventually figured it out, but I'm still waiting for a response. So I have the copies of me applying for that. Madden Litton from the Senior Housing Bureau was waiting on me to let her know where I was with the VA. And around Wednesday, when I was still having issues getting a hold of getting responses back from Madrika, I finally responded to her, but I haven't had a response back. She said there was an opportunity that she could help us. So
That was who,
Senior Housing Bureau of
Housing Bureau for Seniors?
Mhm. Thank you.
Okay, and that's their fund where they could pay, she says you might have access to funding that could pay it all.
Right.
This agent Skip, or I can't remember what the funding's name is. Gotcha. Okay. Okay. So you've been working on it, trying to figure it out.
Right.
I'm shocked that the VA has not given you a response.
Well,
They
well,
did, but they didn't, and part of it is because they're not really open. And the beautiful whole process. We had this nice federal government that just won't work, and now everybody's trapped. And Ms. Manson, you and your client are gonna be mad at me, but I'm gonna tell you, we're gonna come back for a fourth hearing. I'm not kicking the vet out unless I have to. I'm just not.
I do want to say that I own the house. We own the house.
I know. I got
So I don't
you.
know
I
if
appreciate, listen. I appreciate your entire circumstance. I'm just indicating that I'm not kicking a vet out because I know that there are programs there to take care of it, and that absent the ineptness sometimes of our federal government, this would be done. It would be paid for, and you guys could sleep at night, not worry about it. And I know since his difficulties, you've been struggling to try to make it all work. I'm not abandoning you at this point. It's just not happening.
Thank you.
That's just not the way I am. And plaintiff can be as mad as they want at me, and that's fine. I had people mad at me before. I got broad shoulders. I'm going to put it out 2 weeks so that the two things, so that hopefully the Veterans Administration can give an answer within that time. God only knows. But also the individual that you contacted at Housing Bureau for Seniors, if it's I think it's Skip, if it's that funding, tell them that you'd like to apply for that right away. I think what they're going to do is they're going to be waiting for the veteran to see what the Veterans Administration does before they do it, because some of that funding is limited. Ask them if you could get that so this can get paid.
Okay.
Now, how much is your monthly rent?
I think it's $896.
Okay. Are you in a position to pay anything toward your rent at this point?
Not at this point. He's only getting a certain amount, and we have, other bills of like $1,000 a month. And
That's what you guys are living off of right now?
right now, and I had a job at Myers, it didn't work out. They let go a lot of part-time people at that location. So now I'm currently been looking for another job, and I have a job opportunity with the Salvation Army and where we live, our local one. But they're waiting on a background check.
Got it. Okay, so here's what I'm gonna do. November 14th, 2025, what time? 3 PM. And it's likely if we don't have a resolution, I'm gonna give them a judgment, but we'll figure something out. What I'd like to see is that between now and that date, that you at least put $200, about a quarter of what's owed to the landlord.
Okay,
Okay, it's not much, but don't have much to work with at this point.
okay,
Okay,
we'll figure something out.
all right. I know you will, and I know,
Every day, we're working on it.
I know.
Okay,
You guys take care.
I want to thank you, sir, so much.
We'll bring you a sandwich next time. No, no, you don't have to bring me anything. Thank you.
Thank you. Yeah.
Nathan, I think that's it.
That is all for me today. Have a great rest of your day.
You do the same. Okay, now I gotta step off because then we gotta play the video to play the next block.